Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Demorris Hunter. This is out of Florida, Orlando specifically. We are in Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us. Audio works. Always nice to hear the audio. We are in day 2 of the penalty phase. We heard from several witnesses on both sides, and we are going to continue to hear from witnesses on the defense side. So get comfortable, settle in, and let's get started. All right, welcome in, everybody. Welcome in. Thank you for joining us. We are in day 2 of the penalty phase, day 4 overall, actually day 5. My apologies, day 5. Took the jury 3 days to hear testimony and then come to a decision of guilt in the penalty phase, and now we are in day 2 of the guilt phase. So, welcome in, everybody. Who is with us today? Who is in chat? Oh, well, hello. I see little Rikers with us. Wizard of Ezzy, hello. Kimbers, good morning. Shirley, good to see you. Hope you're doing well. The Pretty Chick, awesome. Always good to see you. Kathy Davis, good vibes only. Sending out good vibes to everybody. Let's see, who else? YT Hazel, happy Tuesday to you. Radioactive, good morning. Richard in the kitchen, hello. Good to see you. Appreciate you joining us. Green-Eyed Cat, good morning, good morning. Happy Taco Tuesday. Yes, do me a favor and hit that thumbs up button. We really appreciate it. Yes, we do. Thank you, Green-Eyed Cat. JMS, good to see you. Selena K, have a fantastic flight. And absolutely, I know you'll have a great time. I don't even have to say that. It's like, right, when somebody goes to paradise, it's kind of silly to say, have fun. We know you will. But anyway, have a great flight, Selena, and yeah, have a great, oh, awesome. You're going to send pictures and share. Awesome. Yes. Awesome. Appreciate that. Linda, good morning to you. Let's see. Who else is with us? Let me scroll down a little bit. Stand for the Truth and Heidi, just in time. Good morning and welcome in. Well, good afternoon for you guys. Just Breathe. Good morning. Good morning. Mama, good to see you. Brenda, Allison, good to see you guys. Iowa Backyard Cam. Lots of storms. Yeah, I saw you guys are getting some storms. I hope all is well with you guys. Mary and Cindy, good to see you guys. Camilla, taking Lolo out for a walk. JP Rabbit, good to see you. Welcome in. Michelle, good morning. Barry, good to see you. Just a Girl Baking, hope that you have a lovely day as well. JMS at 61 for you right now. It was 59 when we woke up. That's funny. 59 in Florida, 61 in where you are, up north. Rita, good morning. Good morning. Welcome in. Alice, good to see you. Stella, good morning. Melissa, how are you? Good to see you. Running with Scissors, you're back. Awesome. From your New Mexico vacation. Hope that went well. Hope that was fun. All right. KLN, good to see you. Welcome in. So yesterday, our audio was pretty bad from the court. Court feed was just terrible. Ionine, good morning to you. Camilla, 47 in your city. That's nice. I like 47. 47's nice. All right, so yesterday audio was terrible from the court. So fingers crossed we have a much better feed today. Excuse me. I know the defense still has 3 more witnesses to put on. And those witnesses are going to be, they said, 2 live and 1 recorded. So I hope those ones that are live are not via Zoom, because anything that comes through Zoom is terrible, because they never just, the audio just never goes right into the board. It's basically, it's on a projector, it's on their screen or whatever, big TV, if you will, I guess. And it's coming out of those speakers. So in the courtroom, you can hear fine, right? It's not a big deal. You can hear fine. Hey, Debbie, how are you? Let's see, what's going on with you? You went to the eye doctor. Your cornea is very swelled. Oh, my goodness. Antibiotics and steroids. Oh, I'm sorry to hear that. Sorry to hear that. Well, just sit back, relax, get comfortable. Kelsey, good morning to you. Good to see you. Radioactive 47 in the Bay Area. That's nice. That's refreshing. That's a good weather to get out and take a little stroll. So yeah, so if they're going to be via Zoom, don't expect much. Just work your way through it. It's going to be brutal. I could barely hear the cousin yesterday, Alfred Costa. I really wanted to hear him. We heard from Siobhan Long and Lanice Long. They were his nieces. They are his nieces. His same age, which, again, I'm trying to figure that out. I guess it's possible. That means you have a brother or sister that's 16, 17, 18 years older than you. But it's possible. It's certainly possible. So anyway, they went to school with him. They were Siobhan was in the same grade as Demorris, and then Lanice was 2 years younger. So they were all via Zoom, and it was really hard to hear. Even the lawyers in the courtroom were hard to hear. So there was humming, there was crackling, there was static. It was just really, really tough to listen to yesterday. So I'm hoping the audio cameraman, camera operator has sorted out their audio, because it was not a very pleasant listening experience, that's for sure. So, are you guys losing signal? No, let's see. My Comcast is looking pretty good. You guys are having issues with the feed? All right. I think I'm showing all signs are pointing towards a good signal here. So maybe just refresh. Hey, little Lulu, how are you? Shirley, it's 55 yesterday, but pouring rain. Now I think I caught a chill. That stinks. Let's see. 1 via Zoom and 2 in court. They said 2 live and 1 recorded. So 2 live and 1 recorded. I also interpreted that as 2 in the court. But then when you kind of think about it, 2 live and 1 recorded would mean it's a recorded message. So I don't necessarily know if that's going to be via Zoom. We'll have to wait and see. But that could be interpreted as live, meaning just live via Zoom and or in the court. And then 1 is a recorded message. So we'll have to wait and see. So anyway. I hope it's not via Zoom. I just hope it's okay. Yeah, just refresh. I guess just refresh if you're having issues. On our side, it looks like we're okay. I'm not seeing anything on our side. So just refresh if you guys have issues. You know the deal. You know the drill by now. If you've been with us long enough, just refresh. And if we drop our signal altogether, we'll be doing our best to get back online. Debbie, I'm just going to listen. I will chat if I have something. My eye is very blurry, so excuse my bad typing. I really want to say. Actually, there were no typos in that. So Yeah, just relax. Just relax. Little Lulu saying hello to everybody. Jadzia Dax, good to see you. Good afternoon from the UK. Good to see you. I thought the title yesterday was Penalty Phase. It is. Today is Closings and Verdict Watch. You are correct on all accounts. Yes, we are still in the penalty phase, but we're going to have closings as well, and then the Verdict Watch after that. So it's all going to happen, and all going to happen in one day. So you are correct in that. Amber, good to see you. Missed most of this trial. Is it a DP case? Yes, that is what the jury is deciding on. The jury is, they found him guilty unanimously, and now they have to find him whether life without parole or DP. So yes, this is a DP. General Rod, good to see you. How are you? Good to see you. Let me see if we have a feed yet. No feed yet. Still waiting on our feed to kick in from court. And I do hope their audio is better. I do hope that their audio is better today. Hopefully they took the time to sort out whatever it was that was happening yesterday was just miserable. It was just absolutely miserable. Lisa, good morning to you. How are you? Miss Bree, good morning. It was so hard to hear the people speaking via TV, but I don't think what they said helped that much. It was extremely difficult hearing them. Extremely difficult. But what I was able to hear, Miss Bree, was that the nieces didn't know his mother. I mean, they said he was really good to their mother, but they didn't know his mother passed away. They didn't know he was incarcerated for shooting people. They didn't know about the girlfriend's friend that he shot. Yeah, they didn't know. So they really weren't that close to him. So I agree with you. I agree with you 100%. They were there to give character statements and witness, testimony, and didn't really work for me either. I have to agree. I have to agree with that. Just a girl baking, even with two earbuds in, it was a struggle. It was very difficult. It was very difficult. Mal, big storm's coming today. You're excited. Well, I hope it doesn't knock you out. Hope it doesn't knock your power out. Let's see here. Shirley Roth, did I hear the interviews with the astronauts on the weekend at NASA? I did not, but we are going to do a stream tomorrow, starting around 2 p.m. Eastern. We're going to do our stream tomorrow. We're going to do a debriefing. So I've got news conferences from the astronauts, from the scientists, from the engineers, yeah. So I got stuff for you. I got stuff for us to watch tomorrow. So that will be tomorrow. That will be tomorrow afternoon. So when I was doing my research yesterday, I watched all of like 5 seconds of it because I didn't want to watch it. A, I didn't have time to watch it. B, I didn't want to, spoil it. I wanted to watch it with you guys. Let's see, Barry, you're supposed to have 80 with afternoon showers and storms in Connecticut today, tomorrow, and Thursday. It'll be nice after the winter and chilly spring so far. Oh, it's your birthday. It's your cat's birthday, Wizard. Happy birthday. Oh, there you go. Cat's 5th birthday. Very nice. Kelsey, why do you think the defense wouldn't have told the family of his charges? That seems so wonky. Yeah, you would. I have no idea. I have no idea. Maybe that's tainting their testimony. Maybe that would be, if the state say, hey, did you hear about this? And they said yes. And then, well, how'd you hear about it? Well, the defense told us. Oh, you didn't know about that? I thought you were close. So maybe that's why. Maybe they felt that would be tampering with their testimony. Hey, Ronnie, how are you? Good morning, good morning. Still down, but you're here. Oh, feel better, feel better. Just relax. Just relax. Why do we not have a feed yet, you guys? Come on. All right, still no feed, which is interesting. Usually they go live a little bit before their allotted time. It's the first time they've been late with their feed. Wizard says, Kitty is getting extra treats, laser play, and her favorite flavor of wet food tonight. Very nice. Sherry, good morning. Heading to the hospital for your son's CT scan. Well, you definitely are in our thoughts and prayers, Sherry, and hopefully that will go well. Hey, Downey Lynn, how are you? Gonna be storms where you are as well. Fanny, good morning, good morning. Welcome in. Oh, pretty chick. Welcome to Rabbit Ears. Enjoy the benefits of membership. Appreciate that. Thank you so much for that. Wizard says her name is Georgina, a twist on the Adelson prosecutor Georgia Kappelman, who I was super impressed. Nice. Nice. All right. Well, don't even have a feed yet. So then there's that. Maybe we won't have to worry about audio because we won't have a feed. Then there's that. Let me check the other. Let me check another source just to make sure we're not having issues with that source. All right, they're not live either. All right, so nobody's live. Nobody's live yet. All right. So I know it's not the feed. I know it's something's happening in the court. Then we need a real refund from court, right? Yeah, thank you, pretty chick. That's very sweet. And welcome to Rabbit Ears. Welcome to membership. Enjoy the emojis and the members-only videos and soundtracks. Green Eye Cat, enjoy all the new member benefits. We're glad you're here. Ohio Jen, good morning to you. Kimber saying welcome to Rabbit Ears as well. All right, well, I'll kind of review what happened yesterday while we wait for the feed to kick in. We asked you guys, does Demorris deserve the DP? 73% of you said yes, and 27% of you said no. So that if we were the jury, we still wouldn't have 8 out of 12. You need to get to 75%. So interesting. I wonder if they'll even knowing his prior bad acts, 27% of us still said no. All right, so what I was able to hear yesterday, we can go over. The defense wanted one of the aggravating factors was this was especially heinous, atrocious, and cruel, and the defense wanted to strike that, have that stricken, and the judge said no, we're not going to strike that. Hey, Christy, good morning to you. Squeak cap, yes. You guys are buffering again. I don't know what to tell you. We're looking good over here. I'm not seeing any issues on my end. So I don't know. I'm not sure what to tell you guys. I'm looking like I'm over here. It looks fine. So, hey, Brat. Good morning. Let's see. Shirley says, I voted, but not sure what, because Wi-Fi at the hospital is horrible. Radioactive. Either way, he needs to stop unaliving people. That is true. Jenny G coming in hot with saying hello to everybody. Good job there, Jenny G. Welcome in. All right, so recap such as it is. So the state did an opening. They talked for almost 10 minutes. And they said they were going to bring in 3 witnesses, which included the assistant district attorney, and his name was John Bruhard. And we heard from him. He goes over the arrests and the conviction. So we heard about an Adolphus Williams, Eric Wright, Cesar Guzman, and Jose Hernandez. So, and then we also heard about Evora Huntley. Now, Adolphus, Eric, Cesar, and Jose were the 1985 incident, and he used a sawed-off shotgun for all of those, and he killed 2 people. 2 of those people passed away, and he spent 12 years in prison. He was able to get out in 1997, so that happened in 1985. 1997, he got out. And then in 2002, March 29th specifically, he was he was beating up his girlfriend. I'm not going to sugarcoat it. And her friend came in to try and break it up, and she called the police, and she went outside to wait for the police, and he followed her outside, and he shot her in the face, or actually I think the neck, of course, killing her. But he shot her again just to make sure. So those are 3 people that he, see, they're calling him a serial killer, and he's not a serial killer. He doesn't fit the criteria of a serial killer. We've looked that up before, where there's a moment of reflection. It's about power, control, possibly a sexual nature to it. I don't see any of that with him. To me, it's more fits of rage. I think he just has serious anger management issues, and his impulse control is just gone. So I don't go with the serial killer aspect of this, but he has killed multiple people. And then so that's March 29th of 2002. He takes out Evora Huntley, and then he flees Oakland, California, goes to Orlando, Florida, assumes another name. I think it was Michael Berry, I believe was his last name. And then, of course, the whole Theresa Green thing, Theresa Green incident where something happens to her. I'm still not 100% convinced that he did this. It does seem possible based on his previous loss of anger, his anger management issues. Sparkling Princess, hey, Bama Green Eyes. Shirley Roth, he has a major anger problem, should never be free. Yeah. So I could see him strangling her because he got angry and got upset, but I can also see her falling down the stairs and dying that way. I mean, I can totally see that as well. And then he doesn't want to be involved with it at all, so he steals the truck and he takes off. And he may have even helped, dispose of her body. So that's kind of where I'm at with it. So either way, he didn't want to have anything to do with the police coming in and investigating this. So that's why he took off for Houston, and then they find him in Houston. All right, then we heard from Adria Girardi. She testified about fingerprints in Orlando, pinning him to the incidences in Orlando. And then finally, Brittany Adkins, who was a victim advocate. She read the victim impact statement for Octavius Hayes. And as expected, it was moving, it was touching, it was sad, feel sorry for that. Well, I was going to say young man, but he's no longer. He's like probably in his 30s by now. Well, he was 14 and 20 years ago. So yeah, he's like early 30s or so. And then they rested. And then we had 3 witnesses on the defense side, and they did a brief opening statement, and they talked about it'll be an opportunity to see another side of Demorris. 3 witnesses from California, his cousin and 2 nieces. And then tomorrow there'll be 2 live witnesses and 1 recording. Demorris was exposed to violence, including police and gang, and we'll hear from his daughter. Nobody said anything about police and gang violence. The two nieces said nothing. I don't know if the cousin did or not. I couldn't really hear him. But both of the nieces, they went to school with him. They were his age. One was exactly his age. The other was 2 years younger than him. And they didn't know about his mom passing away. They didn't go to his funeral. They didn't know about the 85 shootings and the 2002 shootings. Both of them didn't know about that. So I found that highly irregular. Why do we not have a feed? Come on. Ugh, are we just not going to have a feed today? I guess they fixed their audio issues. Hey, Ann, I don't know. You guys are saying you're having problems with buffering. I'm sorry, I'm not seeing it here. It doesn't mean it's not happening, but I'm just not seeing it here. So I don't know what's going on. Erin said that she saw some buffering out in the other room, so you guys may be having some issues. It's a YouTube problem today? Is it? Okay. Lori, good morning. Hello. How are you? Hey, lazy boys. Good to see you. Sparkling Princess. Yeah, they clearly did not know him very well. I think that's the thing. All right, some of you are not having issues. Sparkling Princess, Ronnie, Jenny, Wizard. So I don't know what to tell you. Mal's not having it. Hey, Nan, good morning to you. So some of you are having problems, some of you are not. So I don't know what to tell you. I got nothing. Other than I'm just trying to figure out why we don't have a feed from court yet. Like I said, that's one way to fix their audio issues. Just don't have any feed. Because that's not going to be cool if we don't have a feed today. I, for one, will not be happy. Yep. 2 sources, no feed. They've never been late, they've never been late. They've always been on time. If not on time, then even early. Hey, Margaret. C. Gilmore, how are you? Yeah, Ann, I don't know. I don't know if it's on. I don't know whose end it's on. It could be on YouTube's end, and you're just unlucky enough to be having an issue. I don't know. I'm not seeing any issues here. I'm well into the green. I'm streaming full blast. I'm doing really well on my end. So, Camilla, maybe they're having the same buffering issues some of us are having. That's true. They very well may be. Kimbers, I have not had a problem yet this morning, but maybe YouTube today in certain areas. Then there's that. All right. So it could be certain people are having it. Sparkling Princess, I will be so annoyed if we get nothing today as well. Yep. Well, my 2 sources are not showing anything, so nobody's really in chat either, which is weird. I'm checking Kathy Russin on Law and Crime, and they don't even have anybody in their chat. So, all right, so we wait, and hopefully we'll have a stream. Miss Bree, I would like to hear from his daughter's mother. We don't know if we're going to hear from her. is the question. We're going to hear from his daughter. We know that. We don't know. Hey, Debbie. There's another feed on, let's see. No, Court TV doesn't have it either. They're just showing a thumbnail. If CT means Court TV, they don't have it either. Are you talking about Court TV, Richard? I don't know which. I'm on their YouTube channel and I am not seeing it. So maybe I'm having an issue here accessing it. All right. Are you talking about their website or their YouTube channel? I don't know. Clearly YouTube's having an issue right now. What does CT mean, you guys? Tell me, what does CT mean? Law and Crime and Court TV do not have a feed. It could be a YouTube issue that we're not able to access it right now. I don't know, but I'm not seeing it on Court TV or Law and Crime. So, what? Give me more information. Just don't say CT. What is CT? Is that Court TV? What is that, you guys? Please work with me because I'm not seeing it here. It could be a YouTube issue where we're not seeing it. Is it their YouTube channel or is it their website? Because I am not seeing it here. It could be a YouTube issue. I don't know. All right. So it says live, but it's a replay. I'm just not going to trust you guys anymore. You guys get me all worked up and excited because I'm looking at both Court TV and Law and Crime, and they're not live. Hey, Tammy, good morning to you. Happy Tuesday to you. So is YouTube having issues today? Let's see. YouTube is currently operational with no widespread outages reported on April 14th. Doesn't seem like YouTube is having an issue. Sod Girl, how are you? Good morning. Mama, could be a problem with the juror. Tammy, let me tag you. Sometimes that's the issue. If I don't talk or tag somebody, it sometimes is an issue. Try that. Yeah, they could be. They could be having an issue. Loud and clear on your end. Both of them are, yeah, I think they're also, I'm looking at both of those streams and I'm waiting for them to kick in. So, strange thing is though, there's like nobody chatting over there, which is really weird. Law and Crime has people chatting, but usually they have a lot of people chatting. Yeah, they're starting at 9. Um, all right, they're talking about something else. Hey, Michael, good morning to you. Good to see you. Yep. Thank you for that, Wizard. So we wait. Mama of a Medic, good morning to you. Jane, good morning to you, and thank you for that email of the astronauts getting out. Remember when we saw the astronauts, and I'm like, oh, I wish they had cameras so we could see. Well, they did. They all had GoPros on. All the Navy SEALs and rescue operators had GoPros on. So I was able to see a vantage point from that. So appreciate that, Jane. That was really cool. That'll be one of the things we show tomorrow. Is the astronauts getting out, being rescued. I thought that was pretty cool. Sparkling Princess, you watched some of that too? That was pretty cool. Camilla, yes, I did. Did I not? I'm sorry, I didn't reply to you. Yeah, you made the dragon. I think you said you made the dragon and your son made everything else. I did. I thought I replied to you. I'm sorry that I did not. Yeah, that was really cool. That's very cool. Early kitty cam. Well, if they're all asleep, it'd be pretty boring right now. They're pretty, it's all pretty, they're all asleep. Let's see. Can we play Fracture Blue Line? No, because I don't know when they're going to kick in. We'll put a pause on, put a pin in that one, Wizard. We'll put a pin in that one for now. Lucy, good morning to you. Waiting. Are the witnesses for the defense still in California? Don't know. They could be. Hi. Meow. There you go. There's early kitty cam. Little Sid. Hi. Thank you for stepping on my keyboard. Well, if that was the case, Ronnie, if they were all in California, then the judge would not have had everybody come in, would not have had them come in at 9 o'clock. You watched the astronauts speak yesterday? They were funny? Yeah, I can't wait. Debbie, we've been talking about it all morning. It's something clearly is going on with YouTube. I do not know the answer and how to fix it. My end, I show solid green. I'm pumping out solid signal. Some people are having an issue. Other people are not. So I don't know what to tell you other than just keep refreshing. And it seems like it's a YouTube thing today. Elaine, good morning to you. Hope you all had a lovely, relaxing evening and are ready for today. All right. Reason for each cat's name other than Roger and Rafa. Well, let's see. Riker, well, let's see. Super Ball, Aaron named her because when she was little, she was jumping around like a little Super Ball. She literally was like, she looked like a little Super Ball, and she was jumping up on the fence. So that's how she got her name, Super Ball. And then Polly looked like Polly Gualtieri. Polly Gualtieri or Polly Walnuts from The Sopranos. We were watching Sopranos for like the 100th time, and we were deep into The Sopranos. And I thought she was a bobcat when I first saw her in the back. I thought she was a bobcat. Hey, Betsy Jean, good morning to you. Simone, good morning. Welcome in. So her ear furnishings were, sticking out, and she also had a little tuft here. I thought she was a bobcat. I literally thought she was a bobcat. So, so we named her Polly after Polly Gualtieri. And then the kittens were, of course, Rafa's. He's a ginger, so the king of clay. That one was easy. So Rafa Nadal. And then then the kittens were born. So let's see. Riker was first. So William T. Riker. So firstborn. So she's number 1. So she's Riker. And then Sid has a little stripe right here. So I thought that was a mohawk. So she looks like I called her Sid. Sid Vicious, even though he never had a mohawk, but I just called her Sid. And then we had Roger, who we called him Fed for a while, but then we went with Roger Federer, because Rafa had to have a compatriot, and since they're both orange marmalades, so he got named Roger. And then Houdini, because Houdini, she escaped. She was the first one as a wee little kitten. She would always find an escape hatch, I should say. She was always finding a way out of wherever she was. She would find a way out. So there are the names of our kittens. Why Riker rather than Troy? Because she was firstborn. And Troy would be a good name too, but firstborn. So, and we didn't know if she was a boy or a girl, to be quite honest. So, could have been a boy, could have been a girl. We didn't know until later, obviously. Yes, number 1, the penny just dropped. There you go. Elaine, good morning, good morning. Sparkling Princess, I love hearing the stories of all the kitties. Ronnie, perfect names. Thanks. I love Houdini so much. She is beautiful, Mel. She really is. And it's interesting because she always, I want to say she's not standoffish, but like whenever we come in from outside, we always get greeted by 3 cats. She rarely greets us, right? But then at night she'll be like the first one to jump in between your legs or cuddle with you. Like the other, like Riker is very vocal. Riker's like meow meow meow. She's very vocal. She's just always in your face. She just always wants, love and pet. You can always pet her. But Houdini is she keeps her distance, but she's very loving. She's very beautiful, but she keeps her distance much more so than Riker. Roger's sitting right here. He's pretty lovey. He's always around. He always is purring and always wants a pet. And but yeah, Houdini is she likes to escape. She's our little escape artist. Well, I wonder if they're going to start at like 11 or 12 now. I wish they had let us know. I have no idea. Nobody's saying anything in the chats, the other chats. It's quite annoying. Christine, good morning, afternoon, evening. Love hearing about the kitties. Let's see. Lazy boys. Are any of the kitties skittish with people? My brother and sister-in-law came over. Let's see. Yeah, Sid and Roger were fine. And Houdini and Riker. Yeah, Riker can be a little... We haven't really had any workers come over, right? I don't think anybody's really come... That's true. Who was Riker? Riker was growling. Yeah, we had an Amazon delivery and Riker was growling. What about when that guy came for the no, for the cable? What was his name? Larry? No. In December. Don, yeah. They were somewhat okay.
Yeah, everybody was playing with his tools.
Yeah.
His tools.
We don't really have visitors. So that actually, come inside, but we'll hear. I gotta show you. Let me show. Show you a little bean boy here. Little buddy there. He's all relaxed. So are they skitterish? No, not really. Yeah, they're pretty good. Superball is skitterish. Yeah, Superball is. Elaine, you have a little escape artist here, the name of Bramble, but she is a miniature sausage dog. Nice. Mom, I went back and she said, come at 9. I know. That's what I wrote down as well. She said 9 o'clock start, unless she meant 9 o'clock on the West Coast, 12 o'clock here on the East Coast. I have no idea. That is the groan sigh of misinformation from the court. Okay, so Joanne, Jedi Platypus, network disruption. It's not you guys, it's me. An outage might be affecting you. Go to network status. All right, so Brat is saying your landline fiber keeps buffering today while a cell phone is fine, so it's clearly not on your end. Joanne says, I guess it's just one of those days. I refreshed and have a totally black screen. So it is not us, it is YouTube. So it is not us, it is YouTube. If you're having issues, call YouTube and complain. It is not us. Please do not complain to us. It is not us, it is you, Tube. So if you have an issue, call YouTube. I'm sure they'd be happy to take your phone call. JMS Judge definitely said 9 a.m. It's YouTube, it's not us. Yes. YouTube has been wonky the past few weeks. Okay. All right, we have a feed. All right, hold on, guys. So hold on. We have a feed. All right. Give me a moment. We do have a feed. And I can't rewind, so we're just going to go for it.
Going around town in different places and, no, not really. I mean, no matter where I go, have any fear about going around town in different places and, no, not really. I mean, no matter where I go, it's going to be the same, you know. When I come out here, it's the same, you know. No. What about the neighborhood where you lived? Did you all feel safe there? Oh, yeah, it's our neighborhood. You know, I mean, you can live in a good one or you live in a bad one. I mean, I'm a man, so wherever I go, I'm going to be a man. So when you say feeling safer or whatever, I'm going to be safe wherever I go because I'm going to take care of myself because, I mean, that's where I'm built. Look, I'll be honest with you. I'm not sure I have the same level of confidence about going just anywhere. Did you, when you were growing up there, did you feel like you were responsible for taking care of yourself and you needed to know how to defend yourself? Yeah, how about Mr. Hunter? Was he the same way? Yeah, everybody's the same. You know, I mean, we grew up where it's tough everywhere. So, I mean, that was life. Just. Well, that's what I'm trying. I can't explain it, but that's what I'm trying to find out, right? Yeah, I mean, what was life like in your neighborhood? Was it? To me, it was normal. Yeah. So when you say what was life like, it was everything in life is normal. I mean, sure. If you there in it or wherever you are, it's the time you in. Were you aware of like violence in your neighborhood? People getting shot? Or I mean, to me, that's everywhere. Yeah. I mean, it wasn't. It's not as it turns out, but yeah. To me, I mean, yeah. Life is like, yeah. People got shot. I mean, if I come out here, somebody got shot. So
Yeah.
Were you yourself ever the victim of violence?
Yes, I was.
What was that about?
They was trying to shoot somebody I knew. And I was there, Yeah, I was a victim of violence.
You got shot?
I got shot. I've been shot. 89.
Let me ask you a question while we're at this. Have you yourself ever been convicted of a felony?
No.
No?
Never.
Your mom, I noticed that when she was sworn, she did not swear. She affirmed.
No.
Is that because of your parents' religious beliefs?
Yeah.
Were they particularly conservative Christian?
There's Christians, yeah.
And so were you raised in a household where alcohol was forbidden, let's say?
Yeah. Smoke and all that.
Smoke? None of that?
None.
So you never picked up any of those vices?
No, I didn't see no reason to.
And I can understand that, but it doesn't stop us from doing it sometimes.
Yeah,
so you never drank alcohol? You never drank?
I can't say I never drank alcohol. Now I'm grown, but
sure.
Growing up, definitely no. I was raised no smoking, no drinking. Yeah. So I'm grown. Yeah, I had a drink now.
No drugs?
I'm grown. No drugs. Definitely no drugs. I didn't need drugs.
Yeah. How about Demorris? What do you know about his household, the household that he grew up in?
I mean, from what I've seen.
Well, yeah, of course, from what you've seen.
Yeah, whatever I've seen. Yeah. His mom was like my mom. We was kids, so. And we was raised to respect elders, so this was different times. Like we was kids, we didn't have the right to be like grown folks now. Kids today,
sure.
We had to abide by rules, and respect each other's house. So his mom was beautiful. His dad was cool with me. His mom sent me to school. Like out of all the kids, she said, "You go to school for me, Sean." I had to go get the cornbread or whatever. Just normal stuff. So.
Well, I guess what I was asking was, did he grow up in a household where, alcohol and tobacco and that sort of thing was forbidden, as far as you know?
I mean, I can't really say what was in his house, but I never seen his mom smoke. I never seen his dad really just drink or anything. In my memory, I can't really say his dad was drinking or smoking. So
okay. So while the two of you were growing up, would you say that you were good friends?
Yeah, I'll say.
And did you at that time know Demorris to be violent or dangerous or a person who sought out conflict?
No, never. Demorris never go looking for trouble. I can tell you that personally. Never. Now, if you bother me, yeah, we're going to defend ourselves. That's how we do it.
That's how you both were raised?
Yeah, in our neighborhood, we don't look for trouble, but, people in the neighborhood, if they bother you, you're going to protect yourself. I'll say that.
Right. Now, both of your parents talked about Demorris coming over their house.
Right.
Was that a pretty regular thing?
Yeah, he's from the neighborhood. He came to the house. He's like family, so yeah.
Well, both your parents said that at some point he started referring to your parents as mom and pop.
My mom just like I love my mom. My mom loved him just like my mom and dad loved him like a brother. He's like a brother. You know what I mean? So respectful, because if he wasn't respectful, he wouldn't come to my mom's house. Period.
Yeah, that came across from your dad.
Yeah, and my dad didn't play.
Your dad?
And my dad liked straight shooting, and he was a straight shooter. So that's, as far as I'm concerned, that's what it is.
Your dad comes across as somebody who doesn't take any mess from anybody.
He don't.
Right.
He raised us, and I respect that.
Now, at some point, that Mr. Hunter ended up getting in trouble with the law and going to prison, right? And you would have been, maybe 17 years old when that happened?
Yeah, I was 17.
Do you remember this happening?
I don't remember it happening, but I did hear about it. I never really got to the bottom of what he went to prison for because we were teenagers now. He doing his thing or whatever, and I was going to school, whatever. You know, you get older, you start.
Sure.
But we was friends. I mean, we was always friends, though. Yeah. I don't know exactly what happened, but I knew something happened.
Is it fair to say that by this time, and where I guess we're talking about the early 80s or so,
right.
That drugs were in your neighborhood and it was becoming more violent?
Yeah.
And you had to be vigilant to take care of yourself and defend yourself?
I mean, that's from ground up, from kindergarten, you know, to right now. So, yeah,
sure.
I would say that.
So he was out of your life for a number of years.
When he went to jail, yeah.
Do you remember how long it was?
Right, 15, something like that. 15 years. But we always stay in contact. Like,
You stayed in contact with him when he was locked up?
Yeah, always. To this day, always.
And did you see him when he got out?
Yeah, what's that?
What was the first time you saw him after he was released?
I picked him up when he got released.
You picked him up from
I picked
prison?
him up from prison. Yeah, and took him to his grandmother. And his dad was there. His dad didn't even know he was released. He was shocked. His dad answered the door. And matter of fact, he was like, hey, you know, yeah, so yeah.
He would have been in his 30s by then?
Yeah, I said we was 30s. I had a family by then, you know, so yeah.
You had already got married, started having children?
Kids, yeah.
Tell me a little bit about that. Like, how long have you been married?
36 years.
You got a long ways to go to beat your folks.
Yeah.
And how many kids?
I got 2 kids, 3 foster kids.
Really? I don't think you'd ever told me.
Yeah.
3, okay. When Mr. Hunter got out of prison and you went and picked him up, took him to his folks' house, did he go to visit your folks at any time?
Yeah. We visit his folks. We visit my parents. You know what I mean? Yeah.
And did your parents change anything about the way that they treated him?
No, he family to us, so he came in, everybody greeted him like, you know.
Was anybody, anybody hesitant about bringing someone who had gone to prison for violent crimes?
No, they don't even see
in their midst?
Yeah, I mean, no. Even my kids, to this day, they don't see me like, you know what I mean?
Right.
Yeah.
You saw a different side of him?
Yeah, different side. I mean, from what they say of him and what we know of, what I know of him, it's like 2 different people.
Now, at some point, he moved away from Oakland, California?
When you say some point,
Well, I don't want to put words in your mouth in terms of what years that would have happened, but I'm saying at some point after he got back from prison, and now obviously
Yeah.
he moved away from Oakland, California. Did you still keep in contact with him then?
yeah, pretty much.
Were you living in Oakland still, or did you at some point move away from Oakland?
I moved away from Oakland.
Where'd you move to?
First I moved to Concord, then I moved to Antioch.
First you moved to?
Yeah, first, when I left Oakland, I moved to Concord.
Could you spell that for the court reporter?
Concord, C-O-N-D-E-R.
Condor, okay, I'm sorry. I've never heard that one before.
Yeah.
So you moved to Condor, and then you moved to?
Then I moved to Pittsburgh. I bought a house in Pittsburgh.
Pittsburgh? Pittsburgh, California?
Pittsburgh, California.
Never heard of that either.
All right.
Okay.
Then from there, I bought a house in Pittsburgh for my family. Then I bought a house in Antioch.
In Antioch?
Yeah, Antioch.
Like from the Old Testament?
Yeah.
Okay. And that's where you live now?
That's where I live now.
And that's in California too?
That's all in California.
Obviously, you know about why we're here.
Yeah.
And the charges that have been leveled against Mr. Hunter and the conviction that he stands under right now, which is why we asked you to come today and did you ever change your mind about the kind of man that you perceive Mr. Hunter to be?
I mean, it's hard to say because I never seen what y'all saying about him. You know what I mean?
Right.
And what I read is, it's kind of hard because he's my friend, you know what I mean? So I'm a real friend, you know what I mean? I can't judge him off what he did. I wasn't there for one, so I don't even know if he did or not. So he's still my friend regardless, you know? So, yeah, it's hard.
Do you continue to love him as a brother?
Yeah.
And that's why you made this trip out here?
Right.
To let the jury know?
I mean, how can that'd be like being a fake friend, you know what I mean? Like everybody, I mean, life, we all go through something, you know what I mean? So, to me, he's my friend, so, bad or good or bad, I mean, I can't judge him, I'm not God or nothing, so, that's where I'm at. I mean, I feel, from what's going on, whatever, I feel sad for everybody. I think it's all lost on both sides, you know what I mean? So that's really how I feel, you know what I mean?
Well, sometimes we hear about things that people have done,
Right.
and we personally feel betrayed,
Right.
or we feel like they've not been honest with us,
Yeah.
or did you ever?
Your Honor, can we approach?
All right, so this is one of Demorris's probably really best friend, close friend, one of his best friends. Don't know his name yet. Maybe on cross we'll catch his name. But right now it's YouTube's downloading speed. So what you're being downloaded, that's the problem. Upload is fine. We're cranking on upload, so it's the download. Because YouTube has upload and download, so uploading to YouTube is one thing, we're fine. It's the downloading that we're having issues with. So it's not us, it's YouTube. So if you're having issues, just refresh. So it's not us. Just so you know. Thank you, Debbie. I have not checked yet. Like
I was saying, sometimes things happen, and we end up changing our mind about what we thought about a person. Has that happened to you about Mr. Hunter?
No.
You still think he's the same person you've always known?
I mean, he always been straight with me, you know what I mean? Like,
Was he always reliable with you?
always.
Was always somebody
So that counts a lot, yeah.
that you could count on?
Yeah, exactly.
Like if you had ever, been threatened or felt that you needed help, was he somebody that you could rely on to do that for you?
I mean, I never rely on anybody if I've been threatened. I'm a man's man, you know what I mean? I mean, me and him always been straight up for, you know what I mean? We got a connection there. He's a real dude, I'm a real dude, you know what I mean? So,
Yes, sir.
I mean, situation is bad now, but he's been good to me, and I've been good to him, so, I mean, there's nothing I can say that, I mean, the situation is bad, so you got to, balance that, but, I mean, that's far as I can express myself now.
That's fine. That's fine. Thank you very much, Mr. Alexander. I have no further questions of this witness.
Thank you. Cross-examination.
We have no questions for this witness. Mr. Alexander, thank you for coming, sir.
Thank you, sir. You are free to go. Defense, you may call your next witness.
You are called Demorris Hunter.
You are.
solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, ma'am. You can be seated. Ma'am, could you tell me your name and spell your first name for the court reporter, please?
Demorris Hunter, D-O-N-D-E-R-R-I-S.
Thank you. Mr. Self, you may inquire.
Thank you, Your Honor. Please, the court. Ms. Hunter, can you tell the ladies and gentlemen of the jury how old you are and where do you currently live?
Oakland, California.
And how are you related to Demorris Hunter?
That's my father.
And you don't have any memories of your father outside of the times that he's been in jail, correct? And you have a daughter?
Yes.
And how old is she?
She's 6.
And what's her name?
Elaine Marie.
And do you have any recollections of visiting your father when he was in jail in California?
I was like 4 or 5 the last time I saw my father.
Do you continue to have a relationship with him while he's in jail via correspondence or calls or cards?
Yes, letters, phone calls. No visits, but letters and phone calls.
And does your daughter have a relationship with him also that way?
Yes, they told me.
Okay. What does your daughter call Mr. Hunter?
Her grandma.
And that's how you've had to build your relationship through those correspondence and phone calls and birthday cards?
Yes.
Do you love him?
Yes, I will.
Do you have a relationship with him?
Yeah.
Would you like to continue to have a relationship with him?
Yes.
Let me have just a moment.
Okay.
No further questions, Your Honor.
Thank you. Cross-examination.
No questions, Your Honor. Thank you, Madam Attorney.
May this witness be excused? You are free to go, ma'am. Thank you. Defense, do you have any additional witnesses?
No, we do not, Your Honor.
All right. Ladies and gentlemen, I need to take up some matters outside your presence. I'm going to give you a 15-minute recess at this time. Do not discuss the case among yourselves. Don't discuss it with anyone else. Do not do any independent research while you're away from us. And I will see you back in about 15 minutes. You may be seated. Mr. Barrero, your client does not intend to testify during the penalty phase.
That's correct, Your Honor.
All right, Mr. Hunter, I just need to make sure that you understand that you have the right to testify. I know we've had this conversation before. Can I have you raise your right hand to be sworn, please, sir?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Thank you. Sir, could you tell me your name? And Mr. Hunter, your attorney has indicated that you do not intend to testify during this penalty phase. Do you understand that you have the absolute right to testify if you wish to do so?
Yes.
And you have the absolute right not to testify if that is what you want? Right. And is it your desire not to testify in this matter?
Can I have a second?
You may.
Well, he said he did not want to testify, but now they're conferring, and maybe he will. Maybe he will get up on the stand. I mean, at this point, why not? You've got nothing to lose. So we'll see. We'll see if he actually gets up on the stand to talk, to testify in his behalf. I mean, I would say at this point, why not? Just go for it. What do you have to lose? What do you have to lose? So we clearly missed a couple witnesses because he said something about his mom. I heard something about dad. So unfortunately, we did not catch that testimony, but we heard from one of his friends and then his daughter. And I'll do a recap when we do take a break. But we're waiting to hear if he's going to take the stand. Debbie, I'm not seeing the cup of coffee. Oh, there it is. Okay, just came in. Thank you, Debbie. Appreciate it. Thank you for the $10 cup of coffee. Appreciate that. Thank you, thank you. I shall reply to you here as well. All right. Thank you, Debbie. Really, really appreciate that. Yeah, something's going on with like the internet. You know, I don't know. Things are laggy. So it seems like it's the download speed. So what you guys watch, that's considered the download speed. What we're doing right now, we're uploading. Oh.
Mr. Hunter, have you had an opportunity to talk to your attorneys about your decision?
Yes.
All right. What is your decision?
I'll pass this up.
So you're not going to testify?
No.
All right. Thank you, sir. Let's give the jury the lunch order forms and let them start ordering lunch. Any changes to the jury instructions before I print them?
No, Your Honor.
All right.
Not from the defense.
No, Your Honor.
And it would be my intention to just read these straight through after closing argument rather than before. All right. Then it's going to take them at least 10 minutes to order lunch. So why don't you gather your thoughts for about 10 minutes and we'll come back and begin closing argument.
Your Honor, before we break, would the court mind inquiring of the defendant? There were several witnesses that have been listed that obviously for strategic reasons the defense has chosen not to call. Would the court mind inquiring of the defendant if he's spoken with his defense counsel about those decisions of not calling those witnesses in these interviews?
All right. Mr. Marrero, were there witnesses that were listed that were not ultimately called?
Yes, Your Honor. Most specifically, witnesses in regard to Mr. Hunter's mental health and we evaluated the testimony of those witnesses and their the potential downsides, what sort of rebuttal could be expected, seeing as some of them were deposed, as well as reviewing the, we, as the court is aware, we had a previous competency hearing for Mr. Hunter about a year and a half ago, at which I was present, and ultimately it was our joint decision as a team that would not be productive, it would not be valuable for Mr. Hunter to proceed with that defense, given several liabilities which I would rather not put on the record.
Gotcha. All right. Mr. Hunter, did you have those discussions with your defense team with regard to calling those witnesses?
I'm discussing it now.
All right. I'll give you a few minutes while I go copy jury instructions and we'll come back and address it. So we'll be back in 10 minutes.
Interesting. All right. A little interesting stuff going on there. All right. So as I was explaining, what happens, you have upload and you have download speed. So when you watch YouTube, that's it being downloaded to your device, whether it's your phone, your computer, your TV, whatever it is, that's YouTube downloading to you. What we do is we upload to YouTube and then they partition it out and they download it to you guys. So our upload speeds are fine. Everything's fine. Not a problem on our end. The problem is on YouTube downloading to you guys. So YouTube is experiencing some issues wherever you guys are. Some people are having problems. Some people are not. We're having problems here with our download. So our upload is fine. It's the download that's having issues. So I hope that helps explain it. If you guys are having issues with buffering, just refresh. Know that it's on your end. It's not on our end. So you don't need to tell us that there's a problem. We understand that there's a problem, but it is not on our end, and there's nothing we can do about that. So hopefully that will help you guys out there. All right. So from what I could hear, which was they came in like 40 minutes late, and on the stand was a good friend. Did not catch his name. There was no cross, so there was no opportunity to catch his name. But they came in with, he felt safe in the neighborhood. He said life was rough. He said to him that was normal. He said he got shot in 1989, but he's never been convicted of a felony. And this is his friend. This is not Demorris. This is his friend talking about himself. He said, then he said, Demorris's mom, he said, Mom didn't swear. She affirmed when she was sworn in. So I guess we heard from Demorris's mother. His friend says, Demorris's mom was like my mom. He never really saw Demorris's mom or dad smoke or drink. He said Demorris never went looking for trouble, but he said they would defend themselves. So if he were bothered in the neighborhood, so he's basically explaining what it was like growing up. So clearly they grew up together. He considers him a good friend. So he said he's known him since kindergarten. He said if you were bothered, you would protect yourself, though. He talks about the early 80s and the substances that were in the neighborhood. As I mentioned earlier just now, he's known Demorris since kindergarten. Demorris was out of his life for 15 years, but he stayed in contact. He says, still to this day, I stay in contact with him. He says nobody was hesitant of bringing Demorris in after prison. So even though he was in prison for being very violent, they had no issues with bringing him into the house and talking, just hanging out with him and bringing him into the house. Let's see. He says, did you ever change your mind? He was asked, did you ever change your mind about Demorris? And he says, it's hard to say. He says, he's my friend. He says, I wasn't there, so I can't judge him. He says, he's still my friend regardless. He says he still loves him like a brother. He said he made the trip, I'm assuming from Oakland, or actually he said he was in Pittsburgh. So I'm not sure. I guess he said he was in Pittsburgh now. He made the trip to come to Orlando because Demorris is his friend. He says, I can't judge him. He says, I'm not God. He says he feels sad. He says it's a loss for both sides. Then there was a sidebar, and they came out of that. And he said, he's been good to me, and I've been good to him. So he's a friend. He's his buddy, and he's going to stand up for him no matter what. Then we heard from Demorris Hunter, who is his daughter. She's 25 years old. So this happened it's 24 years now. So she's, wait a minute. Hold on a sec. This happened in 2002, 24 years ago. She's 25. Okay, yeah. So she was a year old when this happened. She has a 6-year-old daughter. She said 4 or 5 is the last time she saw Demorris. So he was in jail. So she saw him in jail. She says she still communicates with him via letters, cards, and phone calls. She says her daughter calls him grandpa, I guess. She said she still loves him. Pittsburgh is close to Oakland. No, not really. Then the defense rested, and then there was a question whether Demorris would testify or not, and they talked for a few minutes. Ultimately, he says nope. Then the state talks about several witnesses that were not called. I'm not sure why that's a big deal, because the witness list, there'd be 100 people on the witness list, and they'll only call like 30 people. I'm not sure why that was a big deal. Maybe because they had to depose them. Who knows? Defense says, well, we didn't call them because it was... The one witness was about his mental health, and potential downside was more than the upside. He didn't want to put that on the record. So Demorris had a competency hearing about a year or a year and a half ago, and he says it was a joint decision to not use that in the defense, and that he said he didn't want to put that on the record. And then she asked Demorris if he was okay with that. He says, I'm discussing that with my counsel now. So interesting. So now they're on break. Jury is ordering food. And that's where we stand. All right. Bratt says, I think the state is trying to make sure the defendant won't be able to claim an appeal that he was not allowed to bring witnesses he wanted to bring. Shirley wanted to bring it on the record, but they chose to not call them. That makes sense. That makes sense. Jeff says, defense found a nice way of saying my client won't testify because it'll do more harm than good. Yeah. Yeah, Ronnie, that seems to be the issue. If you're using your phone, it seems to be okay. But when you're using any other device, computer or Apple TV or anything like that, there seems to be an issue. So. Yes, the pretty chick. We know it's a YouTube thing. It's the downloading issue, as I explained earlier. So just refresh. If you're having issues, it's YouTube. It's not us. We are uploading fine. We are streaming fine. It is YouTube that is having the issues when they download to your device. That is the issue. So if you're having problems, just refresh. There's nothing we can do about it. Absolutely nothing we can do about it. So you can take that for what it is. We can do absolutely nothing about it.
Got the final jury instructions for the attorneys. Hunter, have you had an opportunity to have a final discussion with your attorneys with regard to the witnesses that were not called in this case?
Yes.
And are you satisfied with the decisions that have been made with regard to not calling those witnesses?
No, I'm not satisfied, but I understand.
All right. Tell me why you're not
I'm
satisfied.
not satisfied by a whole lot of stuff. We need to move forward.
All right.
We need to move forward.
Do you understand the reasons that the attorneys have strategically decided not to call the witnesses?
Some points.
All right. And do you disagree with other points?
We're going to move forward, so I'm not the whole court process of what's going on in court right now. I know things is not as I perceive them, as I see them. It's reality is in front of me right now. But yeah, okay, we're going to move forward.
All right. Good enough. They're still filling out the lunch order forms. so as soon as they're done with that, we will begin with the closing arguments, and I believe the state gets one shot, the defense gets one shot, and then I read the instructions.
That's correct, Your Honor.
All right, thank you.
I just have a question. How many of these
So he understands the decision. I'm sorry, he's not satisfied with the decision, but he understands. I didn't quite catch what his reasoning was, but he understands why they're not calling these witnesses, but he's not satisfied with that. Hey Mel, how are you? All right, let me see here. I got to get my clock ready. So they're going to have one chance each. Let's see who's going to go first. I wonder who's going to go first. And the judge is off. Nope, she's waiting. So they are making their lunch orders. This guy's life hangs in the balance, and they're ordering lunch. It just seems so bizarre to me. That's so bizarre. Isn't that potential grounds for an appeal? Well, ineffective counsel, not his lawyers not listening to him. I guess Donna could say that then. I mean, anybody could say that, I suppose, right? Anybody could say, I wanted to do this, but my counsel said, yeah, I don't know. I think just about anybody could say that. So, sure, anything could be grounds for an appeal, but will it go anywhere? I think you have to trust the lawyers know what's best. Let's see. State has the burden, so that means they get the last word. I would think so. I would agree with that. I would think so, especially if they're only giving them one shot. Mel, I'm surviving yesterday's very busy day. Thank you for asking. No problem. And Jeff is right. He'll get an automatic appeal with the DP. Life without parole. I mean, I guess, right? You can always appeal. It's like you can always appeal. You can always ask somebody, "Hey, I want to appeal," and then it's evaluated at that point. So. You can always claim something. It's like suing. I can always sue you over something, but is that frivolous? Is it going to go anywhere? I can always appeal. But Jeff, if he gets life without parole, will he stay in California or go back to California? That's a really good question. We figure the DP will supersede California, life without parole. I would think, here's the thing. He's eligible for parole in 2028 in California. In Florida, he is not eligible at all. So which one will take over? Because life without parole in Florida means life without parole. California, we were reading yesterday that he actually has, because he's elderly, we had a whole conversation about that yesterday. Because he's over 50 and he's going to be 60 this year, actually in a couple days, I think the 16th, 17th, 18th, something like that. He just has a couple days to go. And he spent 20 years in jail, in prison, I should say. He falls under that elderly statute. So that's a really, really, really good question. It's a really good question. If he goes back to California, he'll be eligible for parole. In Florida, he will not be eligible. So, interesting. Deviant, hello, how are you? Debbie, not sure which way you go on DP. California may not want him back. Let Florida foot his bills. Then there's that. Does the jury know that he's eligible for parole? I don't think so. I've not heard that. We only read that because it was based on a statute for this elderly. I forget what they call it. Elderly program, something elderly, something program, something like that. Basically, it's if you're 50 and you've spent 20 years, or 60 and you've spent 25 years. I think that's what the breakdown was. DP has automatic appeal. It does, JMS. Let's see, Jadzia Dax. Yes, the right to appeal, but that doesn't mean you'll win. He'll actually put on record that he's not happy with his attorney's strategy. Yeah, I mean, I don't know how that works, but I would think anybody can claim, ineffective counsel, and then what appellate lawyer is going to take it? They could look at the case and be like, yeah, whatever. You know, how many people that have been convicted have claimed ineffective counsel? You know what I'm saying? He's going to be 60 in a few days. So he's 59 right now. Let me check his. He's born April 18th. April 18th. So in another couple days, he's going to be 60 years old. So he's a few short days of 60.
You may be seated. Ladies and gentlemen, the state and the defense have now rested their penalty phase cases. The attorneys will now present their closing arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Mr. Buxton.
Thank you, Your Honor. Can you please court, counsel? Ladies and gentlemen, I don't start my closing argument by telling you good morning, because it's never a good morning when the state of Florida has to stand in front of a jury and ask that jury to recommend a sentence of death on a fellow citizen for a crime he committed. But that's exactly what I'm going to be asking you to do. Sometimes people are required to make hard choices, and though the choice is hard, it is the correct one. And that decision and that choice should be made based on the facts and law of the case and the circumstances surrounding the case. The facts and law are what dictate justice. It is those things that make our justice system work, and that's what makes the justice system uniform and not the product of one person's whim or emotion. But rather, justice is the product of a careful analysis of facts and circumstances and how those facts and circumstances fit into the laws that we have all agreed to live by. You heard some people in jury selection say, look, I don't care what the evidence says. Me personally, I cannot vote for the death penalty. And that's okay. I respect those people's honesty and their integrity, because if they hid that information from the parties, this system would not have been fair. This trial would not have been fair. Each of you swore that if you felt the aggravating factors outweighed the mitigating circumstances, and you felt that that penalty was appropriate, that you could in fact vote for the death penalty. We are asking you as the state of Florida to do just that, because the facts and the circumstances and the law support the death penalty as the appropriate sentence in this case. The easiest decision might be to go back in the deliberation room after we're all done and say, look, let's just give this guy life and go home. But ask yourself, is that justice based on the facts and circumstances of this case? Is that justice based on what the defendant did to Theresa Green? Is that justice considering the defendant has already been convicted of another first-degree premeditated murder? As I said, sometimes the right decision is not the easy one. The instructions that the judge is going to read to you in a few minutes, and you've heard very similar instructions when we were doing jury selection, but they're going to give you a detailed process that allows you to go step by step using the evidence, reason, and logic to reach your conclusion. I expect the defense will tell you this several times, and while it is true that your decision as to the proper sentence in this case is an individual determination by each of you, I don't want anybody to think that that means you're not supposed to go back to the deliberation room and actually deliberate. The law requires you to talk and deliberate and discuss the evidence with each other. Our jury system is so wonderful because we bring people from different backgrounds, different upbringings, different lives, different things that you've experienced throughout your life, and we put you together to talk about and resolve important matters. And it is that discussion and that exchange of ideas and opinions and interpretations of the evidence that makes the ultimate decision well-reasoned and well-informed. It's the willingness to listen with an open mind to other people's opinions and interpretations of things that you may not have thought of that makes the decision well-reasoned and well-informed. So I ask that when you go back to the deliberation room, that you discuss the facts and circumstances of the case. Discuss the aggravating factors that you've heard and the mitigating circumstances. Talk about it amongst yourselves. And after each person has had a chance to discuss their opinions and tell each other what you think, only then take a vote and start marking up the verdict forms. That process is what makes the ultimate decision in this case well-reasoned and fully informed. I want to talk to you a little bit about the mitigation that's been presented to you over the past couple of days. And much of that testimony is about the defendant's background, his upbringing when he was a young man. Anytime somebody commits a crime or multiple crimes, it not only affects the defendant and the defendant's family, the victim's family, but also those people who knew the defendant. And these witnesses presented by the defense have come in not because of their choice, because of that man's choices. Listening to their testimony over the past several days, it sometimes may become easy to put in the back burner or forget about what really brings us here, and that is the murder, the heinous, atrocious, cruel murder that this man committed on Theresa Green. And that's why we're here. I ask each of you in jury selection to promise me that you would and could meaningfully consider any and all mitigating evidence presented to you. And you all said you would. And I asked you to do that. And I asked you again to go back, discuss the mitigation, talk about it, reflect on it, meaningfully consider it. But I submit to you that when you do that, the mitigating evidence that has been presented to you deserves no weight. The defense's mitigation consists primarily of friends and family members of the defendant, some who have had really no contact or limited contact with the defendant for over 40 years, coming in and telling you when they knew him, the person they knew years ago, he was a good guy. Those people seem like very nice people. There's no question about that. I mean, you heard from Sherman Alexander this morning. 3 foster kids, 2 of his own children, he's doing well in life. And some of those witnesses, especially the Longs yesterday, it was difficult to listen because they became teary-eyed. They became upset because their loved one, no one wants to see their loved one in this position. But again, they are not here because of your choice or their choice. They're here because of Mr. Hunter's choices. Not only his decision to murder Theresa Green, but his decisions that he's made throughout his life to hurt other people as well. Some people that you heard, some of the mitigation witnesses you heard, knew him 40 years ago and had limited conversations with him, limited interactions, if any interaction. When he was over at the Alexander's house as a kid, you heard that he was respectful. He acted right. He followed the rules. So we know he can follow the rules. He can be respectful. He can do what people do if he chooses to do so. Sherman Alexander was raised in the same neighborhood as the defendant. Sherman Alexander has no felony convictions. Sherman Alexander hasn't killed 3 people. Sherman Alexander was raised in a similar household. He said, look, his parents, the defendant's parents, were similar to my parents. Sherman Alexander still supports his friend. He is a true friend, and regardless of what the defendant has done in his past and done in this case, Sherman Alexander still supports him like a friend probably should. Some people said the defendant, when he was young, was nice, was funny, was respectful. I submit to you, ladies and gentlemen, being nice does not mean that a life sentence is appropriate. Being nice when he was a teenager to an elder does not mean that a life sentence is appropriate in this case. I believe one of the Longs said yesterday that he took care of his daughter, that she watched the child when the defendant went and got Pampers. Well, ladies and gentlemen, I submit to you, that's what a parent does. That's what every parent should do and is legally obligated to do. Because the defendant did what a parent should do for his own child does not mean a life sentence in this case is appropriate. It is interesting that I don't think any witness knew about the defendant's prior violent criminal history. They may have known he was in prison and he did something bad, but none of them knew any of the details. The person they may have known 40 years ago is clearly not the man that this man has become. They clearly did not know the true side of the defendant, the violent side, the side that time and time and time again chose to hurt people. They knew the person that the defendant chose to show them. They knew the person that the defendant was as a child. Alfred Costa testified yesterday that the defendant came and lived with him in Houston, lived with his house, and then he moved into Alfred Costa's grandmother's house. Mr. Costa didn't know that the reason he went to Houston was because he was fleeing because he murdered Aurora Huntley in California and then murdered Theresa Green here in Orlando. Mr. Costa did not know that the defendant was a fugitive of justice from 2 murders. The witness's knowledge and impressions of the defendant are at best incomplete. Ask yourself, how much weight do you give their testimony and their opinions and their impressions of the defendant, especially when they're based on their impressions, really about 40 years ago, especially when their opinions and their impressions are based on half the story, not the story of the defendant's criminal acts. Simply because there are some people in the defendant's life who, again, based on decade-old impressions, say they love him, does not mean that the death penalty is not warranted in this case. Everyone can find somebody in their past to come in and say, when I knew him, he was a great guy, I loved him. That doesn't mean the death penalty is not the appropriate punishment here. The witnesses that have testified didn't know the details of his prior crimes. They didn't know the details about how he killed 2 people before killing Theresa Green and how he hurt 3 others by shooting them. They didn't know about the pain that he has caused other families because of his choices and his decisions. If they did, you think they would have said the same thing about the defendant. You think their impressions may be different. There's no doubt the defendant has people who love him. But it is also clear that the defendant's history of choices that he has made not only hurt his own family members, but also the friends and family members of the people that he just hurt, like the Butlers, like Octavius Hayes, the son of Theresa Green. I stressed in jury selection, please go back and consider this mitigation. Please do. After you do it, I submit to you that the mitigation presented by the defense and the opinions of these friends and family members, many of whom are really uninformed about the defendant's true character, should be given no weight at all. I want to shift gears and talk about the aggravating factors that the state has presented. Like we talked about in jury selection, and like the judge will read you, aggravating factors are factors that increase the gravity of the crime or the harm to the victim. They are factors that make this first-degree murder of Theresa Green more egregious than other first-degree murders. The state only has to prove one aggravating factor beyond a reasonable doubt for the death penalty to be an appropriate sentence. Here the state has presented two. Your first decision is going to be to determine if the state has proven those aggravating factors to you beyond a reasonable doubt. If you find that the state has proven an aggravating factor, that factor then goes on your weighing scales to determine what the proper punishment should be. First aggravating factor the state has presented to you is that the murder of Theresa Green was especially heinous, atrocious, or cruel. And this addresses from the victim's perspective, from Theresa Green's perspective. And notice the word or. Mr. Nunley told you in an opening statement that it is not and. The state doesn't have to prove that the murder was especially heinous, atrocious, and cruel. It's or. So if the state has proven any of those three modifiers, then that has been proven. I submit to you the evidence in this case has proven all three. This aggravating factor, again, focuses on the victim's perspective and how she was feeling, the pain and suffering that she endured before she eventually died. The judge will tell you that heinous means extremely wicked or shockingly wicked. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. Kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless, pitiless, and was unnecessarily torturous to Theresa Green. For this aggravating factor to apply, the state has to prove that the victim, at the time that she was being killed, was conscious. Because if she was unconscious, she would not be aware of what was happening to her. She wouldn't be experiencing any kind of pain and suffering because she's unconscious. So what evidence do we have to show that Ms. Green was, in fact, conscious at the time the defendant was murdering her, was strangling her? Obviously, and I expect the defense may point this out, there was no witness who came in here and said, look, I was there, I saw the defendant strangling her, and the victim was aware he was conscious. Why? Because people don't strangle other people in front of witnesses. That's why you have to look at the facts and look at the circumstances about, as far as the case, and the circumstances surrounding how this murder occurred. So how do we know she was conscious at the time she was being strangled? Well, we know from both medical examiners, both Dr. Arden and Dr. Utz. Remember, Dr. Arden was the medical examiner the defense called. Dr. Utz was the medical examiner the state called. Both of them said that in their review of the autopsy documents and records, they saw no evidence whatsoever of any kind of a skull fracture, no evidence of brain trauma, a brain bleed, anything like that. Nothing to indicate or to suggest or that would cause her to fall into unconsciousness like you would if you fractured your skull. The autopsy would have shown that, and there was no evidence of that. So there's no indication or no reason to think that she was not conscious. Her blood alcohol level was about a 0.28. Again, we know from the testimony of the medical examiners that that number is likely artificially inflated. Why? Because she was undergoing decomposition. And during the decomposition process, we know that the bacteria in the body cause fermentation and cause alcohol to be produced. How much? We don't know. That is undetermined. But witnesses said she was impaired. But keep in mind, ladies and gentlemen, when her and the defendant tumbled down those stairs that night in that hallway, testimony of 3 witnesses, Joseph Butler, Joyce Butler, and Lisa Moore, all told you when she got to the bottom of the stairs, she stood up and she walked up that flight of stairs, step by step. No one had said that she had to carry her, or she was so impaired or so out of it they had to pick her up and drag her up the stairs. She walked up there on her own. So ask yourself, how truly impaired was she? And I submit to you that even if she was impaired, when the defendant has his hands wrapped around her neck, that fear, that adrenaline is going to take over. That basic animal instinct of flight or fight is going to take over. She's going to be fully aware of what happened. We also presented to you some physical evidence to show that she was conscious when she walked into that apartment with Demorris Hunter. You heard about the watch that was found. The watch with the defendant's DNA was found on the ground, and Octavius Hayes picked it up and put it in the bathroom counter. But you heard that watch was broken. If she would have walked into that apartment, fallen onto the bed, into unconsciousness, why would that watch be broken? We know that the band wasn't broken when she fell down the stairs because it was still on her wrist and it ended up being in her apartment. No one said they saw her pick up this broken watch, broken inside the house. That is indicative of a struggle. That is indicative of Ms. Green being conscious and being aware during a struggle. We also have evidence of that hole in the wall that Octavius said wasn't there earlier. Again, that is evidence of a confrontation or altercation inside that apartment after they entered that apartment. If she would have walked into that apartment, fell onto the mattress, fell into unconsciousness, why do we have a hole in the wall? The hole in the wall is because there was an altercation, which shows she was aware and conscious. There could be an argument, maybe she walked in there and she was so drunk she fell into the wall and caused that hole to happen. Well, if that were the case, and that's all that we have, don't you think the defendant would have maybe called 911 or called for help if she was that off and fell into the wall? We know that didn't happen. And to believe that happened, you'd have to ignore all of the evidence of the strangulation, the hemorrhage, and the highway vote that we've all been heard so much about. The evidence on her neck. Which brings me to the physical evidence on her body. The injuries to her neck show that she was conscious during the strangulation process. She was conscious when the defendant had his hands wrapped around her neck and was squeezing the life out of her. Dr. Utz, the defense I'm sure will point this out to you as well, Dr. Utz said, look, I can't tell you with any possible doubt whatsoever that those are fingernail marks, but they sure look like fingernail marks to me. And you have to, again, look at the facts and the circumstances surrounding this case to determine what causes those marks. When you do that, the only reasonable interpretation is these marks were caused by fingernails. Look where they are. They're in the exact place where they would be on her neck if he has his hands around her neck, squeezing. Can we tell you, can Dr. Utz tell you, are those fingernail marks from the defendant or from the victim? We don't know. But in either scenario, the presence of those marks and how they appear show that she was conscious and she was aware of what was happening when she was being strangled by that man. They're not just 4 marks in a row, 4 simple marks. If she was unconscious and the defendant decided to then strangle her to death, she's not. If she's conscious, she's not resisting. If she's unconscious, you squeeze, you hold, you squeeze until she's dead. Here, we see chaotic pattern of marks. We see multiple marks in different locations. What does that indicate? It indicates that he is squeezing and releasing and squeezing and releasing and moving his grip around to cause these additional marks. Why? Because she's conscious, because she's aware, and because she's fighting and struggling and thrashing. If they're from the defendant's fingernails, that is why there are so many different marks in different locations, because he's repositioning as she's struggling and squeezing. If these marks were from the victim's fingernails, well, we clearly then, it's obvious that she would be aware and conscious, because what she would be doing is reaching around her neck, trying to fit her fingers between his hands and his fingers around her neck, to try to pull his hands off of her neck, to try to stop the strangulation from happening. And in that process, she is causing those marks on her own neck. And you saw they're on both sides. She's trying her best to pull his hands away from her neck over and over again until she is no longer able. That's why there are multiple sets of marks like that. So regardless of whether these marks were caused by the defendant's nails or the victim's nails, both scenarios show that the victim, Ms. Green, was aware, was conscious, and was fighting. Fighting to survive. Because we know she was fighting to survive and struggling, we know she was aware, we know she was conscious, we know she was understanding what was happening to her. She was aware that the defendant, her boyfriend, somebody she supposedly cared about, was wrapping his fingers around her neck, around her throat, and squeezing. That fear would have been unbearable. Second by second, minute by minute, she's looking straight at the face, straight in the eyes of that man as he's putting that pressure and squeezing the life out of her. Eventually, she would start to drift in and out of consciousness, and she would still fight and thrash and struggle. And as she would loosen, the defendant would loosen his grip because she's struggling and fighting. That blood would go back into her brain to cause her to remain conscious and remain aware. Common sense tells you during that process, she would have panicked. As she struggles and manages to loosen his grip, that terror would be starting to set in. And eventually, she is going to realize that she is going to die. She struggles until she can't struggle anymore. She can no longer thrash. She can no longer fight. Only then does she thankfully drift into unconsciousness. Only then does her awareness of this horror end. Only then does her pain and does her suffering and does her sheer terror stop. And as the defendant continues to strangle her, only then does she die. Ms. Green wasn't shot in the head. Ms. Green didn't have an immediate death or an instantaneous death. Her pain and her suffering, her mental anguish and her terror was prolonged and it was drawn out. There is no doubt, ladies and gentlemen, that this murder was conscienceless and pitiless. There is no doubt that this murder was unnecessarily torturous to Theresa Green. This murder was heinous, atrocious, and cruel under any set of definitions. Why does this aggravator deserve great weight? Because this aggravator goes to the sanctity of life itself. No human being should have to endure the suffering that Theresa Green did at the hands of that man. This aggravating factor alone outweighs any mitigation that is presented to you. But the state has presented more. The state has also presented a second aggravating factor. That the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Why is this aggravating factor so weak? First, it shows that the murder of Theresa Green was not an isolated incident. Sometimes people act harshly. Sometimes people use bad judgment, make bad decisions. Sometimes people do things as a result of an isolated incident. When a person has prior convictions for violent crimes, that's not the case. When a person has convictions for felonies that involve the use or threat of violence to another, for felonies that inflict both physical and mental harm upon other people, it becomes obvious that violence is in that person's nature. That's the case with the defendant. Violence is part of who he is. He's demonstrated that for a long time. He's demonstrated that since about 1985, at least, when he was 19 years old. That violence has progressed, as shown by the different convictions that he has acquired over the years, and how the severity of those crimes that he has committed has gotten worse and worse. You heard from Assistant District Attorney John Brillhart. You also saw some documents introduced by the state showing the records and the documents of his prior criminal convictions, all from the ones in 1985, as well as the one in 2002, for which John Brillhart was the actual trial lawyer that prosecuted the defendant for where he's found guilty of first-degree premeditated murder. The violent crimes that the defendant has committed in his life were not committed all in one day against one person. This is not a situation where he had a one-time lapse of judgment and racked up a bunch of felony convictions in one fell swoop. His violent crimes were committed mostly on different days, in different ways, in different events, and on different victims. You heard from John Rohard, who explained the documents proving the prior convictions, and they are in evidence. I know they're relatively small up there, probably difficult to see, but they are in evidence. And he explained to you the nature of his prior convictions, both from 1985 and regarding the first-degree murder of Deborah Huntley that happened in 2002. He explained to you the unique PFN, or personal file number, to make sure that we know that these convictions all relate to that man. And Mr. Rohard, remember, also identified the defendant as the person that he prosecuted for the 2002 murder of Deborah Huntley. You also heard from a fingerprint analyst from Orlando Police Department who compared his known prints, the defendant's known prints, to the fingerprints taken of the person who was arrested in California when he was brought back in 2003. They're the same person. So there's no question, I don't expect there to be any dispute, that all these prior convictions that have been introduced are the result of his actions, this defendant's actions. The defendant's decision and choice to begin committing violent crimes began around 1985. And you heard that on January 6th of 1985, the defendant was convicted. This is when the offense happened, but he was later convicted of voluntary manslaughter with a firearm on victim Cesar Guzman. In that same event, on that same day, he was convicted of assault with a firearm with victim Jorge Hernandez because he pointed the gun at Jorge Hernandez with the apparent immediate ability to carry out that threat. Moving on to the next month, in February 4th of 1985, the defendant shot Adolphus Williams with a sawed-off shotgun, and he was eventually convicted of attempted first-degree murder with a firearm causing great bodily harm. 10 days later is when the defendant then shot Eric Wright. He was convicted of attempted first-degree murder with a firearm, again, causing great bodily harm to Eric Wright. And then, March 29th of 2002, the defendant shot and killed Deborah Huntley. He was convicted of first-degree premeditated murder, just like the murder of Theresa Green. After he commits the crime against Deborah Huntley and murders her, he then flees to Orlando, where he makes contact with Theresa Green and starts up a relationship with her. And now we know why the defendant was using a fake name when he was here. We know why he was going by Mike, because he was running from the police in California because he killed Deborah Huntley there. Less than 2 months after murdering Deborah Huntley, he comes to Orlando and murders Theresa Green. He then flees to Houston, where he is arrested, and then he is brought to California to answer for the charges regarding Deborah Huntley. He is convicted of first-degree premeditated murder there. Then he is brought here to Orlando, Florida, to face the charges that he got here. The defendant has been convicted of not one, not two, but 5 prior felonies. And ultimately, the defendant has killed 3 people and tried to kill 2 others by shooting them. When you consider whether the defendant deserves life in prison, when you consider if he deserves leniency or mercy, consider his lifetime of violent criminal behavior in the people that he has hurt and killed. This aggravating factor deserves great weight, and it alone also vastly outweighs any mitigating circumstances that have been presented to you. I submit to you, ladies and gentlemen, when you place the mitigating evidence that is presented to you on a scale, and then you place the aggravating factors on that scale, your scale should tilt far towards the death penalty because the aggravating factors vastly outweigh any mitigating evidence presented to you. Once you make that determination that the aggravating factors, in fact, do outweigh the mitigating circumstances, the next step in your process, according to the instructions the judge is going to read to you, is to determine what is the proper punishment. I expect the defense will tell you several times that the law never compels or requires you to vote for the death penalty. I told you that in jury selection. That's a given. But what you do know is there are about 9 pages of instructions that you either have been given or are going to be given, and the judge is going to read to you, that will walk you through and guide your decision-making process. After listening to the evidence and determining that there are very weighty and sufficient aggravating factors, and those aggravating factors outweigh the mitigating circumstances, that logical and reasoned moral judgment should be that a life sentence is not warranted in this case. This is an emotional decision, ladies and gentlemen, but I submit to you that the law is most fair, the process is most fair, and the integrity of the judicial system is most fair when your decision is reached based on reason, logic, and a logical method applied in your decision-making process. This decision is a very difficult one, ladies and gentlemen, and it should be. But as I said earlier, sometimes the hard decision is the right one. Each of you in jury selection swore that if you felt the aggravating factors outweighed the mitigating circumstances and you felt the death penalty was appropriate, that you could vote for it. But remember, ladies and gentlemen, the ultimate responsibility in this case sits right there with Mr. Hunter. He is responsible for the choices that he has made in his life. He is responsible for his decision to strangle Theresa Green to death. He is responsible for the decision to commit murder, and he is responsible for causing pain and suffering and death to people in his past. He's responsible for where he sits right now. How many families does the defendant have to destroy before the death penalty is appropriate? How much pain and suffering does the defendant have to cause before the death penalty is appropriate? How many people does he have to kill before we say, enough is enough? Thank you.
Mr. Self.
Ladies and gentlemen of the jury, this is the most solemn phase of any proceeding in our system of justice. You've already carried out your duty determining the guilt of our client in this case, and now the law asks you something even more difficult to do. Decide whether or not to recommend whether a human being should live or die. This is not a decision about what happened, it's a decision about what should happen next. In Florida, the law is clear. Before you can recommend death, the state must prove the aggravating factors are so weighty, so compelling, that they outweigh all mitigation, and that death is the appropriate and just punishment. If even one of you, after careful consideration, believes that life is an appropriate sentence, then your voice matters. Your oath matters. Let's talk for just a second about the aggravating factors that Mr. Buxman just talked to you about in closing argument. And we're going to rely on some of the evidence that was talked about in the guilt phase, obviously, in this case. But I'm going to address the second factor, the heinous, or the first one that he talked about, which I think was the second one that they put on evidence about. But with regard to heinous, atrocious, and cruel. We believe that you will be provided jury instructions. So two areas that I've marked on this page that talk about first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of or the suffering of others. Leave this here for just a second. While the state has argued that the killing was heinous, atrocious, or cruel. Those are powerful words. Words meant to evoke something beyond the already terrible reality of a homicide. But not every tragic death meets that legal standard. The law requires something more. The law requires that heinous be extremely wicked or shockingly evil. Atrocious be outrageously wicked or vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even the enjoyment or suffering of others. Well, the state would have you believe the worst possible story. In the guilt phase of this case, you weren't asked to determine whether the factors that went into how this first-degree murder happened. You were presented evidence, and the state has put together their version of the worst possible story. They would have you believe that there was this drunken party, and Mr. Hunter and Miss Green went back into the apartment and had a fight or had a struggle, which is that there's utterly zero evidence with regard to any of that. There's zero evidence with regard to how the hole got into the wall. You may have heard a lawyer argue at one point, I think Mr. Nunnerly may have argued that that may have been a shoulder in some sort of fight or dispute or disagreement with Mr. Hunter. If you look at the height of that hole, the height of that hole is specific to where the bathroom door catch is. And there are photographs that are placed into evidence that suggest that it starts at about 24 inches off of the bottom of the ground and goes to about 36 inches off the ground, which is right about where the door handle catches into the bathroom, which is right about the same level as somebody's bottom or backside, right? It's not the height of the shoulder. Miss Green was 5'5" tall, which is over 60 inches. If you discount the height of her head, which is another foot, then you're talking about to be shoulder height to be pushed into the wall would have to have been somewhere between 45 inches and 55 inches high up onto the wall. There's no evidence that Theresa Green was ever pushed into that wall. There's no evidence that Mr. Hunter was pushed into that wall. There's no evidence that Mr. Hunter was in the apartment in the first place, with the exception of his DNA on the blood on the watch. Now, what's more likely, using your common sense, did the watch get broken when Theresa Green fell and tumbled down 14 steps from the top to the bottom? Or during some fictitious argument for which there is no evidence that a watch was broken during an argument? It makes no sense. It defies common sense. So this version of stringing together a hole in the wall and a broken watch, there's absolutely no evidence with regard to any of the state's theory about heinous, atrocious, or cruel. You heard or saw the medical examiners, both Dr. Utz and Dr. Arden, testify with regard to the photographs that were shown. Both agree that there is some sort of hematoma or bruise on the back of her neck. Again, what's more likely that hematoma or bruise occurred during a fall and a tumble down 14 steps? They both indicate that they did not believe that had anything to do with strangulation or evidence of strangulation. Once again, there's no evidence of Mr. Hunter's DNA or fingerprints on the body. There's no evidence of Mr. Hunter's DNA underneath Miss Green's fingernails. There's no evidence of her own DNA underneath her fingernails, meaning that whatever the state's version of the scratch marks, and there were numerous of them, far more than 4 fingers. Does someone have 10 fingers on a hand that would cause that? Or is it more likely that that scratching that took place there was a result of a tumble or a fall down 14 stairs over carpet, over concrete, to the bottom landing? Or, as Dr. Arden testified, he believed that that was evidence of slippage, the skin slippage, because of the way that the body was placed into the trunk and the pressure, as you see the photographs of her face out of the car, some of the slippage of the skin in that location, that also occurred on that side or that portion of the neck. And Dr. Arden testified that he did not believe that any of the other evidence in the surrounding areas would support evidence of strangulation. Dr. Utz agreed that it could have been from a fabric, could have been from some other abrasion, but it was his ultimate opinion that he believed that there was evidence of strangulation. We don't believe that there's any evidence of heinous, atrocious, and cruel. Going back to Miss Green's blood alcohol level, it's very important to understand that at a 0.288, there was testimony by Dr. Arden, I believe Dr. Utz may have agreed with this, that the fermentation process that may have taken place doesn't always take place, and they actually have no evidence of it taking place in this case, but that could attribute an additional 0.08 to someone's blood alcohol level. So at a 0.288, we're talking about going to this is math, sorry, but into the tenths, right? The sort of second digit after the decimal place. That 0.08 could have been added. So if you subtracted that out, her blood alcohol still would have been a 0.20, which would have been more than double the legal limit to drive. She clearly was intoxicated. She was clearly intoxicated based on what Mr. Butler testified to. Her drinking, she was drinking Captain Morgan's, and she had been drinking. She drank a whole bottle. Her behavior would suggest that she had been drinking and that she was intoxicated. She slapped Mr. Butler on the way out. She got into an argument. She tumbled down the stairs. All of that is evidence of intoxication. The medical examiners cannot tell you how long it took Ms. Green to die by strangulation. Dr. Utz and Dr. Arden said it could take seconds, it could take minutes. They don't know. And there's no evidence in this case of how long it took her to pass away. We would suggest that there's no evidence that the state has not proved beyond a reasonable doubt the evidence of heinous, atrocious, and cruel. All death is sad, and all death is terrible. But all death is not heinous, atrocious, and cruel. In jury selection, we talked about a sort of special subset of all first-degree premeditated murders, right? Killing an innocent person by an individual, not because they're crazy or self-defense or any of those reasons. And there was a reason that we asked you those questions, right? And all of you swore that you could follow the law and follow your oath as jurors, and that you would agree that, as the state mentioned in their closing argument, that if you got the opportunity or you believe that the aggravating factors outweighed the mitigating factors, and after careful consideration, even knowing that you don't ever have to come back with a verdict in favor of death, that you could. So the possibility that you could do that. You also swore the same to us, or talked about being able to do that as well. So that if the aggravators, even if the aggravators outweighed the mitigators, you still could consider all of the mitigators and give it meaningful consideration, and you still could come back with a life verdict. So we all stand before you on even footing, asking you to take a look at the actual evidence, not a narrative spun by the state to make Mr. Hunter look like a monster. This is not about trying to demonize an individual so it makes it easier to kill him. This is about looking at the actual evidence in this case and trying to reach a determination about whether or not Ms. Green died in a way that was heinous, atrocious, and cruel. We do not believe that the state has proved that based on all of the actual evidence in this case. Let's talk about the second factor. The second factor was Mr. Hunter's past. These judgments and sentences. And the state argued to you that he's been convicted of 5 prior violent felonies, and that 3 people have been in. But he showed you in that 4 of those 5 circumstances all took place in 1985. January and February and ultimately March of 1985. Mr. Hunter was 18 years old in Oakland, California at the time all of those incidents took place. By the way, all those incidents took place with a firearm. Even the later murder in 2002 took place with a firearm. Obviously, in this case, we're not talking about a firearm. There's no similarities, there's no consistency of that. Mr. Hunter's not a monster who goes around shooting people randomly. We don't know what the facts, obviously, of the 1985 case are specifically. We did not hear any evidence from Assistant District Attorney Brewhard that Mr. Hunter was in a gang. He was a gang prosecutor in Alameda County for a long time. He would have provided that information if that were relevant or pertinent. So we don't know what those circumstances are when he was 18 years old and got himself in a series of trouble in those months in 1985. We hear a little bit more about the circumstances in 2002 involving the friend of his wife that was shot under those circumstances. But I ask you, why are we judging an individual by the worst 4 or 5 days of his life, as opposed to what we tried to attempt to do in the penalty phase, which is to present individuals from Mr. Hunter's past who know him. They know him on the mundane days, the 7th grade days, the 9th grade days, the 10th grade days, the after high school days, when he has a child and a baby in this world. All of those days, if you look at the Alexanders who lived in New Mexico, if you look at his best friend Sherman Alexander, if you look at the Long sisters who he went to school with and how he knew them afterwards, they've known Mr. Hunter for years collectively. And we tried to present a side to him to show you that he's not a monster. The state's trying to say he is. And we're trying to say, but the people that know him best for all of this time, that they're saying he's not. That's not how he is. He cared very much for the Longs and took care of them when he went to school with them. He made sure that they went to school, that they did their homework, that they got lunches when they couldn't afford it. He took care of their mother. He was respectful. He was respectful to the Alexanders. He came over to their house. He rode bikes and mini bikes and dirt bikes and things like that with his friend Sherman. And he was, for all intents and purposes, a normal kid growing up in Oakland, California. And then in the 80s, things get violent in Oakland. Things take a turn for the worse. The state would have you believe that just because Sherman came out of it without a felony conviction, that he's somehow a successful product of Oakland, California. We would argue to you that Sherman had been shot during his youth in Oakland, and maybe that had some impact on what happened in 1985 with Mr. Hunter in terms of the violence that was taking place in California. And maybe that had an impact on him. remember, at the end of this case, your decision is going to be between a recommendation of life without the possibility of parole and a death sentence. And what we're trying to say is that, according to the law, life without the possibility of parole is a valid decision and a valid sentence that punishes Mr. Hunter for his actions in this case. He's not a monster. He's not a monster that needs to be put down. We don't need to light torches and create pitchforks, sharpen our pitchforks, because the penalty is going to be appropriate either way. But what we're trying to argue is that there is this other side to him, a human side to him, a friend, a person who cared about the people in his life. You also heard from the Butlers and Lisa Moore and even Octavius Hayes that up until this incident, they never witnessed Mr. Hunter ever be violent or aggressive or angry in any way, shape, or form towards Miss Green. So Mr. Hunter isn't. And so when you have to make the decision as to how much weight to give to the aggravators versus the mitigation in this case, I would argue to you that judging a man by his 2 worst days, and I'm going to lump those 4 events from January to March as one series of events, but basically we're talking about two days of his life. 4 days if you actually count them individually. But weighing that against a lifetime of being a good friend, a good son, a good father to his child who he's never seen outside the walls of a prison, still maintains a relationship with her, still corresponds with her, corresponds with his granddaughter. So he is here. Asked to do after you make your determination about the state's aggravating factors and whether they've been proven beyond a reasonable doubt. Again, it's the defense's position that they have not proven heinous, atrocious, or cruel beyond a reasonable doubt. Is you're going to then be asked about the mitigators. And the mitigating circumstances in this case that we believe the defense has showed you is that Demorris Hunter grew up in a violent neighborhood in Oakland, California, where he had to learn to protect himself and others. That Demorris Hunter was generous and kind to his friends and family. And that Demorris Hunter was protective of his friends and family and tried to keep them safe and out of trouble. That Demorris Hunter was respectful and obedient to his elders. Demorris Hunter was a loving and attentive father to his daughter, the relationship that they have. Demorris Hunter earned the love and affection of his friends and family who love him still. And the existence of any other factors in the defendant's background not mentioned above that would mitigate the imposition of the death penalty. Remember, mitigating circumstances can be anything we've said or done or emphasized, or anything at all, anything that you've heard that you believe is important. And ultimately, again, the state's going to, as the state talked about in their closing, they're going to ask you to weigh the aggravating factors and the mitigating circumstances. And I would argue to you that the mitigating circumstances, the evidence of his life, right, every day, all of those days, the mundane, even the mundane stuff, who Demorris Hunter really is, clearly outweighs his worst day, the prior convictions. And again, even after this weighing process, regardless of the results of each juror's individual weighing process, even if you conclude the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. As we talked about in jury selection, each one of you gets to put on your little robes and make decisions about this case. And all of your decisions individually are important. We talked about how no one would bully someone out of their position, and that others would try to protect people who were being bullied out of that. If one of you believes that life is the appropriate sentence, then that is your decision, and your decision and that decision is perfectly lawful pursuant to these instructions. Respect that moral process, respect your moral decision, respect others' moral decisions, and record that vote. A sentence of life imprisonment is not mercy without consequence. It is accountability. It is punishment. It means he'll spend the rest of his life in a prison cell and he'll never be free again. It protects society. It ensures that he will never harm anyone outside those walls. But it also leaves room for something else. The recognition that human beings are more than their worst thing that they've ever done. I know sometimes in closing arguments, I sit here and I think to myself, and I think you'll hear part of the jury instruction will say that if the lawyers have done anything, that you shouldn't hold it against our client. I heard my voice on the Alexander's video depots from New Mexico, and it drives me crazy whenever I hear my own voice on video. And so if you think that we have said or done something, either Mr. Marrero or myself, please don't hold it against Mr. Hunter, our client. Hold it against me. Okay? But as lawyers, obviously we have jobs to do, and we advocate on behalf of our clients. Sometimes I think I struggle for the right words to say in closing arguments, that I'm trying to be super convincing, the best possible version of myself. But I want to read to you some quotes from others that talk about death penalty cases. And I think it's important to hear perspective of others. Martin Luther King Jr. once said, "Returning hate for hate multiplies hate, adding deeper darkness to the night already devoid of stars."
This point to be approached.
You may.
All right, so state called for a sidebar. He was talking about, what did he just say? Oh, he referenced Martin Luther King.
The objection sustained.
The state needs 8 votes for death, but the law also requires the power of one conscience, one voice, one juror who says, "I've heard everything, I've weighed everything, and I cannot say death is the appropriate sentence." If you are that juror, if there is any hesitation, any doubt about whether death is just and necessary outcome, then the law does not ask you to set that aside. It asks you to honor it. This is not a decision you can undo. No second chance to reconsider. So I ask you to look at the evidence carefully, to weigh not just the aggravation, but the mitigation, to consider not just the crime, but the person, to recognize that even in the darkest circumstances, the law allows for life. And if after doing that, even one of you believes that the sentence of life is the right sentence, then you must stand by that belief. Because in this moment, your judgment is not just permitted, it is required. Thank you.
Thank you, gentlemen. Ladies and gentlemen, I'm going to begin reading the jury instructions on page 1. Members of the jury, you have heard all of the evidence and the arguments of counsel. It is now your duty to decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether at least one of the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime, and that should be or the harm to the victim. So if you can make that change on page 1. I'll start that sentence again. An aggravating factor increases the gravity of a crime or the harm to the victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state are: 1, Demorris Ann Hunter was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crimes of attempted murder, voluntary manslaughter, and assault with a firearm are felonies involving the use or threat of violence to another person. 2, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Theresa Ann Green. You have heard evidence about the impact of this murder on the family and friends of Theresa Ann Green. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Theresa Ann Green's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that is more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You do not need to reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: A, Demorris Hunter grew up in a violent neighborhood in Oakland, California, where he had to learn to protect himself and others. B, Demorris Hunter was generous and kind to his friends and family. C, Demorris Hunter was protective of his friends and family and tried to keep them safe and out of trouble. D, Demorris Hunter was respectful and obedient to his elders. E, Demorris Hunter was a loving and attentive father to his daughter. F, Demorris Hunter earned the love and affection of his friends and family who love him still. G, the existence of any other factors in the defendant's background not mentioned above that would mitigate against imposition of the death penalty. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist. And 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that to the number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, benefit, or preferred treatment to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 8, has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped. Can I have the attorney's approach, please?
Seems like there was some error there, something with the wording.
The entire paragraph on the entire first paragraph on page 7, it is inapplicable to this case. I'm going to start reading at the second paragraph on page 7. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You should not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decision must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. 3, your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Let me read that again. 3, your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision. 5, your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by the foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. And you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the jury room. And just like last time, the deputies will collect your phones and electronic devices and keep them safe for you when you go to the jury room. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. During this trial, certain items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. All of the exhibits will be sent into the jury room with you when you begin to deliberate. And I'm telling you, I'm sending you all of the exhibits, so there will be no other exhibits to send back to the jury room. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another or one decision over another. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. And before I read the last paragraph, I'm going to go over the jury verdict form with you. I think you'll find this to be self-explanatory when you get into the jury room, but it is longer than the jury form that you had last time. At the top of the page is what we call the style of the case, And about a quarter of the way down the page, it says jury verdict form penalty phase. And it reads as follows from the top to the bottom. We, the jury, find as follows as to Demorris Ann Hunter in this case. A, aggravating factors. We, the jury, unanimously find the state proved beyond a reasonable doubt that Demorris Ann Hunter has previously been convicted of another capital felony or a felony involving the use or threat of violence to another person. There are two possibilities under that statement. One says yes and the other says no. When you've reached a decision as to that first one, the foreperson would put an X or a check mark on the appropriate line. The next sentence reads, we, the jury, unanimously find that the state has proved beyond a reasonable doubt the existence of the fact that the first-degree murder was especially heinous, atrocious, or cruel. Again, there are two lines underneath that statement. One is yes, and the other is no. Once you have reached a decision with regard to that factor, then the foreperson would put an X or a check mark on the appropriate line. The next paragraph reads, if you, the jury, answered no to every aggravating factor listed, Demorris Ann Hunter is not eligible for the death penalty, and he will be sentenced to life in prison without the possibility of parole. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. Section B, jury recommendation as to the death penalty. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. There's a capitalized, bolded section there. It says check only one. And it reads as follows from the top to the bottom. The top statement reads, we, the jury, have unanimously found the state has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factor is or are sufficient to warrant the death penalty, and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris Ann Hunter should be sentenced to life in prison without the possibility of parole or death. And then there's a line. It says, we, the jury, find Demorris Ann Hunter should be sentenced to life in prison without the possibility of parole. Then there is another capitalized word, or, right here, and the second statement is as follows. We, the jury, have unanimously found the state has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factor or factors is or are sufficient to warrant the death penalty, and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris Ann Hunter should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of blank to blank that Demorris Ann Hunter should be sentenced to death. Underneath that, it says, dated this blank day of April 2026 in Orange County, Florida, and today's the 14th day of April, with a signature line for the foreperson. When all of you have made decisions in this case and the foreperson has filled out the form, the foreperson would knock on the jury room door, let the court deputy know that you've reached a verdict, and the court deputy will assemble all of us together to receive your verdict. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Counsel, could you approach?
All right, so jury is going to be deliberating in a few minutes, pretty much lunchtime.
Ms. Diotil, you are still our alternate juror, so you will not be going back to the jury room with the other jurors. Did you leave things in there? All right. The court deputy will get a description of those from you in just a moment, and we'll collect those for you. And I'll be back with you in just a moment. For the balance of you, you can take your jury instructions, notepads, and pens. The evidence and verdict form will be sent to you shortly. Your lunch is probably not here yet, but it is? It's on the way. It's on the way. All right. So your lunch will be here shortly. If you have a question, I've already told you how to do this, and I know you know how to do this. You have your foreperson write a note, knock on the jury room door, and the court deputy will assemble all of us together to deal with your question. And with that, I'm going to send the 12 of you to the jury room to begin your deliberations.
Jury executive. Jury.
You may be seated. I really, yeah. And this is what she said, you need it, and I'll take those. Thank you. It's kind of like being a bridesmaid, not a bride. But you did serve an important function. As you see, we lost a juror early on in this case. Unfortunately, her dog got sick and killed. So, if another juror had not been able to return, if you get another summons in the next year and you don't want to serve, check the box to serve in the last year and you're automatically. Thank you. And you have my judicial assistant's phone number if you want to find out what happened, what your fellow jurors do in this matter. She will help this week on vacation, and she will do that. Thank you.
She gonna go back to the, or take it back now?
We're going to take a batch now. I'll take a batch.
All right, gentlemen, I'm going to correct the verdict form, and then if y'all could also examine what's going back to make sure only those things that should go back are going back.
Yes, ma'am.
And then just email the verdict forms to you. All right.
So 41 to 45.
All right, I just emailed it. You can make 3 copies. Just take that out.
I thought maybe the judge might talk to the attorneys about what evidence is going to go in. Well, we'll stay here as long as we have audio. Closed captioning, she said, look at the verdict forms. Closed captioning said, look at the bird forms.
Yeah, It doesn't matter. I just wanted to make sure it. Yeah. But I saw you did the same thing. All right, is the evidence
Yes.
in proper form, only things that have been admitted are included?
Yes, ma'am.
All right, and we're getting the verdict form.
Why turn the audio off? She's not off the record or whatever. Why turn the audio off? Ugh. The camera operator in this trial has not been my favorite. Not happy with said camera operator. She's talking. She's in the middle of talking about verdict forms and evidence. She's right there. She hasn't gone off the bench. Leave the audio on. Ugh. All right. I guess he wants, or they want to go get lunch. Like, hey, 12 o'clock, I'm union. I'm out of here. Even though it's 11:58. Yeah, Kaylee, they are just trying to annoy us. I agree. Go train them. I would get yelled at for the hot mic. I'd be like, yeah, let me turn that up a little bit. Let me zoom in. Let me make sure I can hear what they're saying. I would stay on way later than I would get yelled at, I'm sure, for staying on too long. But they're probably unionized and they're probably like, all right, it's noon, it's lunchtime, I'm out of here. Yes, Debbie, and the sound is bad. Well, actually, today the sound was pretty decent. All right, seems like they are... No, she's still there. She's still on the bench. Why? Just why? All right. Almost high noon, right? Yep. Kaylee, I do love to eavesdrop. Yeah, they're still milling about. She's still there. She's still on the bench. I see her little blonde head. All right, we have a poll going. How long do you think the jury will take? And we had another one. Knowing what you know now, does Demorris deserve the DP? 73%. I think that's pretty much what we said last time. I think our polls on that have been pretty accurate. Let me see what we did last time. So did the state meet their burden? It was 59 to 41. That was initially. Then so it was 70 out of 215 votes after day one. Yesterday, okay. Yesterday it was same question. Does he deserve the DP? Same question. 215 votes, 73% to 27%. 78 votes. Knowing what you know now, does Demorris deserve the DP? Again, 73% to 27%. Is that even like statistically possible? 215 votes to 78 votes? Is that who's a statistic whiz? Is that statistically, mathematically possible? That one vote, one poll, 215 votes, another poll, 78 votes, and both came in at the exact same percentage. Where are my statistical whizzes out there? Where are my statistical wizards? Does that make sense? Horse Welfare, how are you? Welcome in. Amber, good to see you. Yeah, YouTube's been having issues with the downloading of streams today. Uploading, we're fine. It's the download. We're having problems here. Aaron is having problems watching on our Apple TVs. Well, on our TVs with Apple TV. But I'm fine on my desktop. I'm looking at the other desktop. That's fine. Some of you are having problems on your phones. Others are not having problems at all. Let's see. Do we have any statistical wizards out there? Amber? Nope. Ambi? Nope. Anybody? Bueller? Anybody? Can anybody answer that statistically? I'm terrible at statistics. Although I love them. I do love statistics. Still consider the 2 to 3 plus or minus. That's better than the 5 to 10% wizard. I'm like, holy, is our chat just that that blind that they don't know, or they're that inept that they don't know how to take a poll? Joanne, you have issues with your issues? Yes, Amber, I saw Kelsey Fitzsimmons was in court for review of a restraining order Justin had on her. Judge vacated most of it, and she will now be allowed visitation with her son. Awesome. Awesome to hear. That is so good to hear. Yeah, I knew that she was in court today. We were looking for a feed just in case, if they had it, we would grab it. Oh, that's great. That's so good to hear. So good to hear. Hey, well, I think it's 78% of the people that voted. I don't think they are comparable. I only math under duress. Pound cake for me. Thank you. Jury has to hit 75%, but then the jury was DP qualified, so there'll likely be a higher percentage than chat. I'm just interested in that we took 2 polls. One was 215 votes. The other one was 78 votes. And they both came in statistically at the same. 73 yes, 27% no. Interesting. Oh, they did stream it, Amber. I thought it was Family Court. I didn't think they streamed Family Court. Do they stream Family Courts? Ooh. Huh. I didn't think they streamed Family Court. I didn't think they streamed Family Court. All right. Interesting. All right, so let's go through what we heard for jury instructions, which I thought were actually pretty good. I thought these instructions I thought were very interesting. Okay, so jury instructions. Aggravating factors must be proven by the state beyond reasonable doubt. Those are, aggravating factors are previous felonies. Did the state prove beyond a reasonable doubt that he had previous felonies? And then the Theresa Green strangulation, and I guess basically just the strangulation, was heinous, atrocious, and cruel. So the aggravating factors must be unanimous. So they have to be unanimous on the aggravating factors. So if they are not unanimous, then he is not eligible for the DP. That's really important. It's not just go back and say DP or not. You have to look at the aggravating factors versus the mitigating circumstances. So aggravating factors must be previous felonies. Did they prove that? And then heinous, atrocious, and cruel. So definitely I think they can show his previous felonies. I think they proved that. But was the heinous, atrocious, and cruel? And if you remember, the defense was trying to throw that out. Hey, Anthony, how you doing? Welcome in. The defense tried to throw that out yesterday. If you guys remember that, the defense tried to throw that out. So they must be unanimous on those two things: previous felonies, heinous, atrocious, and cruel. Then if they are unanimous, then he is eligible, not edible. Jesus, typo. Are you kidding me? Eligible, not edible. God. Eligible for DP. Then they must consider additional matters. So first of all, they just don't go back in. See, I've never served on a DP case. I've served on one criminal, one civil in New York, but I've never done not even close to DP. So I thought they'd just go back and say, yep, DP or nope, DP. So They have to get through the aggravating factors. Then if they get through that, then they have to consider the mitigating circumstances. So, mitigating circumstances are the defense. Now, it's the defense must prove, but not beyond a reasonable doubt. So they don't have to prove it beyond reasonable doubt. They just have to prove it's more likely than not. So their bar is not as high as the state, which makes sense. You're putting a person, you're ending their life. So it's pretty big. So they just have to do more likely than not. And it doesn't have to be unanimous. All right, so it doesn't have to be unanimous either. All right, so his mitigating circumstances are he grew up in a violent neighborhood. Okay, so have millions of others. I get that. He was generous and kind. Okay, so have millions of others. Or millions of others are. He was protective to his family and friends. Again, millions of other people are. He was respectful to others. Millions of other people are. He was loving and attentive to his daughter. Millions of other people are. He earned love and affection of friends and family. Yep. Any other factors not mentioned that would spare him? So I guess we could just throw out, sure, millions of other people are, but they don't do what he did. So anyway, I thought that it was interesting that she added other factors not mentioned that would spare him. What does that even mean? Other factors not mentioned that would spare him. How can I then apply that if I don't even know what was mentioned? All right. So less than 8 votes, life without prison. 8 votes or more. It's not binding. She said it's not binding, so that gives us our answer. Remember, we were looking that up yesterday. So it's not binding, so the court will give great weight to that decision. So if they do 8 or more, 8 out of 12, then the court, it's not binding. The court can then, there's a Spencer hearing, they're going to go through another hearing, and then the judge will decide. Judge has final say. The judge has final say. Then she started to talk about, she referenced, the defense referenced a Martin Luther King quote, and she started to read that, and she stopped and she called a sidebar. And, oh, wait a minute, hold on. No, I'm sorry. Strike that. No, she was talking about a witness testimony claim to have helped. That's what she said. That's not applicable. Sorry, it wasn't the Martin Luther King. That was the defense. Sorry, that's my bad. So she started to read about this witness testimony claiming to have helped. Then she comes back with choose a 4-person. She goes over the verdict form, find as follows: aggravating factors, state proved beyond reasonable doubt, previous felonies, heinous, atrocious, and cruel. If no, then life without prison, not eligible for DP. If yes, then go to section B. Then they recommend DP. If less than 8, life without parole. If 8 or more, then DP. She called a sidebar, and then she talked to the alternate juror, and then she went to go talk to that alternate juror. So, yeah, that was an awkward typo. Edible for DP, would that be considered cannibalism? Ack. Oh my God, that's just wrong. Abuse of a corpse, right? Yeah. Oof. That was quite the typo. And or autocorrect. All right, so this case really is helping me, because the other one, Jose, oh my gosh, what's his name? Jose Soto Escalera. Jose Soto Escalera. Yeesh. The Jose Soto Escalera trial, that was a DP we watched last September. And I'm sure he read the same jury instructions. I just don't recall them. No, this was great. Now I really, really understand. The judge definitely has final say. Can go down, cannot go back up, meaning if it's DP, she or he can go down, judge can go down. If they go life without parole, judge cannot go up. 8 of 12, we knew that already. They have to consider aggravating factors, which is great, and that has to be unanimous. No, it's really great. Yes, Jose Soto Escalera. I was going like Oscar, I don't know what I was trying to say there. I was getting it all mixed, all tangled up. It's all tangled up. Horse welfare. Glad I put Sarah Boone on your bingo card every day now. Yes. Well, when we're doing a trial out of Orange County / Orlando, chances are, chances are there's going to be a reference to Sarah. Because that's where she was tried. Let's see. If he gets life without parole, the judge can't override it. Yes, that is correct. So she can go down. So she can go from, I'm sorry. Yeah, she can go if they recommend DP, she can go down to life without parole. She can, if they recommend life without parole, she cannot go up to DP. So. Brett, Florida used to allow the judge to override. Upward. Supreme Court overturned the rules they used then. Was that the federal or was that the state? Or was it both? Brett, that's good. That's good info. Which was it? Was it the feds? Was it the federal or was it the state? If you can let us know, that's good info. Just let me know. Because then what's the point of having a jury, right? What's the point of having a jury if the judge is like, yeah, no, I'm going to disregard what you guys said. That's no fun. I mean, that's not fair. Again, I'd be like, I'm a jury. I was a juror. I don't want that person to have the DP. What's the point? Barry, I can make any trial a reference to Sarah too, right? Widespread. Honestly, Sarah Boone is the gift that just keeps giving. She can't stay out of trouble. Right. Same with Lori Daybell. Right. And Donna, what's Donna been up to? We haven't heard much from Donna. What's her deal? Is Donna still? I haven't really seen anything about her recently. Well, it's probably getting close for us to be feeding kitty time. We can do some kitty cam while we wait. I just have to be very attentive because if they come back, I don't want kitties to be playing and we miss their decision. Right, Super Ball? What say you? What say you, little Super Ball? Superest of balls. All right, Jenny G. Gonna make a phone call? Hi. I think you want food. Yep, I think it's time for them to make food. I'm sorry, kitties are hungry. Yes, they are. Sparkling Princess. Super Ball's right here. Yo, dude. Yum, 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 yum. Oh, big yawns. Okay, good girl. Donna's always up to something. Yeah, Donna's always up to something. Now, wait, now don't go picking on Donna. She's your role model. Oh, I see. That's your role model. So it was the feds. Okay, thanks, Brett. Yeah. All right, that makes sense. That went up to the federal level. Thank you for that. All right, you have fans, Super Ball. You have fans. Oh, it's a Super Ball. Superest of balls. Super Ball. Oh, yeah. Okay. That's a good girl. All right. Hell Rider, have a good one. Somehow tagging you isn't working. I made a typo above. Oh, that's working. I can see it. I saw that. Did the other one not? I think I saw that one too. Oh, wait a minute. Oh, okay. Oh, you added an extra E in there. Yeah, you had an extra E. You had an extra E. Happy kitty. Yes, she is a happy kitty. All right, Christine, welcome back. No, you have your fan base out there. You have your fan base. All right, I'm going to get some kitty cam going. We'll feed them, and I'll keep this up because if they come back, I don't want to miss much. I don't want to miss anything. All right, so I'll get some music going, and I'll make myself a little bit larger. But if they come back, I don't want to be. Let's see. I certainly don't want to miss the verdict, so I'll keep a close eye on what's happening here, and we'll go ahead and feed them.
Think something new under the sun. You can't take back them things you already done. No. You blame things that you do on somebody else. No. But they all see is you need help. But still you try so hard to cover up your games. You try so hard, hoping that one day something gon' change. You waste all of your time covering up your tracks. Spend all your days running away. Now you gotta watch your back, and that's the facts. You spend so much of your life scheming and trying to get over. Got you wondering why you come around. All you get is cold shoulder. Yeah, you try so hard to cover up your games. You try so hard, hoping that one day something gon' change. You try so hard. Yeah. You try so hard. that is bad. I'm not walking by myself. You see my brother next to me. We don't care what we'll be. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. On the road, living death. They are walking by themselves. You see my feathers close to me. I'm not scared of what I see. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand. I'll never walk alone again, 'cause I'm still walking with my friends. I play this song with my hand.
It's gotta be against the law to look this damn good. Watch out now. Cause baby, I feel real good and I wish I would. Watch out now. It's gotta be against the law to look this damn good. Watch out now. Everybody watch out. Watch out now. I'm ready for a good time, and I came to groove. The whole band's here, and we came to move. Got a fresh haircut and 2 new shoes. We're here all night like we got nothing to lose. I'm coming out the jacket, cause we're turning up the heat. I wanna see you clapping when you get up out your seat. It's time to make it happen when we hit these streets. I'm coming in hot, and I can't be beat. Watch out now. Baby, watch out now. Watch out. I'm on the move, I'm going up. I'm a man on a mission with no missions, and I'm looking for love. Oh, I'm just looking for love. It's gotta be against the law to look this damn good. Watch out now. Cause baby, I feel real good, and I wish I would. Watch out now. It's gotta be against the law to look this damn good, baby. Watch out now. Everybody watch out. Last call for some alcohol, and don't forget to tip. The sun went down, but we still rolling. The band's still going, playing all the hits. I can't stop now, too legit to quit. I'm coming out the jacket, cause we're turning up the heat. I wanna see you clapping when you get up out your seat. It's time to make it happen when we hit these streets. I'm coming in hot, and I can't be beat. Watch out now. Everybody watch out. Watch out. I'm on the move, I'm going up. I'm a man on a mission with no missions, and I'm looking for love. Oh, I'm just looking for love. It's gotta be against the law to look this damn good. Watch out now. Cause baby, I feel real good, and I wish I would. Watch out now. It's gotta be against the law to look this damn good, baby. Watch out now. Everybody watch out. Watch out now. Everybody watch out. Watch out now. Watch out!
that girl?
No, stop it, man. I saw her first.
My Lord.
Nah, back off, man.
Yeah. First time I saw you, I knew I had to have you. Don't mean no one night stand. Gotta find a way to be a man. It's something about the way you turned and looked at me. Your smile, it turned me on and set my mind at ease. I'm trying hard not to stare. Don't wanna look thirsty. Just trying to play it cool. Gotta show you that I'm worthy. You walked in on the air and seemed to leave this room. I just had to find a way to get next to you. I'm here to testify. Give me a chance, I'm satisfied. Captivate your heart and I'll blow your mind. Don't wanna pass me up cause I'm one of a kind. Eyes up, you're checking me out. Trying to figure out what I'm all about. Wondering if my love will make you scream and shout. If I don't at first, I'm gonna figure it out. Wolves howling at the moon, peacock and acting like a fool. Unbothered as you sit through all the nonsense they throw at you. That type of thing don't interest me when it comes to you. I can't wait to show you that my love is true. Don't wanna miss my chance. Would you mind if I took your hand? Out on the floor, baby, let's dance. Extended cut, DJ, make it last. We're the only ones in here, we're so into this groove. Intoxicated by the way our bodies move. Hey, chance I'm satisfied. Hey, and I'll blow your mind. Don't wanna pass me up cause I'm one of a kind. So, you're checking me out, trying to figure out what I'm all about. Come on, if my love will make you scream and shout. If I don't at first, I'm gonna figure it out. Chance I'm satisfied. Figure out and I'll blow your mind. Don't wanna pass me up cause I'm one of a kind. So, you're checking me out, trying to figure out what I'm all about. Wondering if my love will make you scream and shout. If I don't at first, I'm gonna figure it out.
All right, welcome back, everybody. Welcome back. Hope everybody had a nice break, I guess. Take a lunch if you had one, dinner. So we are on verdict watch, hour and 15 minutes. And we were looking at our Apple TVs while we were eating and feeding the kitties and everything. And it freezes for us after like 30 seconds. Wasn't even lasting like a minute or two. It was freezing after 30 seconds. Oh, you made BLT sandwiches? Nice. How did that turn out? How did your BLT Sammy turn out? Your Sammy. Digesting your BLT sandwich. Pop, pop. Aussie Gardner's dancing to the tunes. Good vibes. I like those little emojis. What are those? What are those little emojis? Looks like a little person. What is that? I can't quite tell what that emoji is. All right, I found them under YouTube's emoji by searching music. Oh, okay, she's singing. Is that, all right. It does kind of look like it's a music note. That's cute. I like it. It's a person with headphones on and a music note. Ah, okay, gotcha. Thank you. Yep. Decide if you ever want to become a radio DJ. All right, Richard, let's see. You may have jinxed it, but it may be fixed. You reported it to YouTube every 3 minutes all day. It's been 20 minutes now and no buffering so far. Yeah, we were like, it was like 30 seconds and it would stop. 30 seconds and it would stop for us. Let's see. Janice says, person with headphones listening to music. Gotcha. Thank you for that clarification. And welcome in. Glad you are with us. Is it Janice GH? Would you say that Janice GH? Or is it Jan Ishk? Janice or Jan? Using your Trial TV Live koozie? Awesome. Thank you, thank you. Hey, Scott, how are you? Welcome in. Got it. Thank you, Janice. Want to make sure I get your names right. I don't want to mispronounce your names or, I want to do your names justice and proper. So thank you for that. So Janice, very cool. Lazy boys. I can see the headlines now. Shocking scene in Florida as kittens seem underpaid. We do all the work and don't get paid. Yeah. Talk to your union rep. Talk to your union rep. Linda, it's so nice to have all the windows and doors open. It won't last long being from Connecticut. Super Bowl tail by, right? Now she's sitting over here flipping her tail back and forth. Iowa Backyard says Dozer is still recovering from the thunder. He's camped out under the sofa and is not going anywhere anytime soon. Aww. Has the weather calmed down at all? Has the weather calmed down? All right, how long will the jury take to deliberate? 0 to 1 hours. We're already at an hour and almost hour and a half. So 11% of you thought 0 to 1 hour. So that's not going to happen for you guys. Sorry. 1 to 2 hours, which is the time frame we're in right now. 43% of you thought. 43% of you thought 1 to 2 hours. So that's the time frame we're in right now. 33% of you thought 2 to 3 hours. And then finally, 12% of you thought 3+ hours. So right now we're in the time frame of 1 to 2 hours. Elaine, welcome back. You have an overloaded full tummy. Who's the union rep? Super Bowl? Yeah, she's the heavy. She's the heavy. She just goes around and thwonks on everybody, thwacks everybody. So she's the heavy. She's the fixer. Super Bowl is the fixer. Who would be the union rep? Yeah, well, she doesn't really perform, so she could just be the union rep. Am I seeing movement? Is that camera moving? Let me head over to see if Kathy Russin is doing anything. I think nobody really cares about this channel or this. I'm sorry, this. What do you call it? This trial. Yeah, Janice, it is kind of moving a little bit. All right, Richard, I just tagged you. Does she do wet work? Well, I don't know. What does that mean? Does she do wet work? What does that mean? Elaine, yes, it is moving. Okay, I thought so too. Yeah, Janice. I'm basing off of when they came back last time. It was definitely, you could clearly see the camera moving. And we saw heads. I don't see any heads right now. Richard says, one thing YouTube suggested was to toggle off then on Bluetooth. After I did that, you're fine. Okay. Super Bowl in the side hustle. Does she do the wet works? I don't know. What is wet works? Am I going to have to Google that? What is that? All right, so Aaron just said that our Apple TVs now are lasting for 5 minutes and then shut down, or last 5 minutes and not? Okay, so it seems like YouTube's issue may be clearing up. Because it was 4 minutes and then it would shut down. Then when we were at lunch, it was 30 seconds and it would shut down. And now it's at 5 minutes and counting and has not shut down. So I think maybe the issues are, have been cleared up. All right, seems like the issues have been cleared up. Oh, I got you. Okay, she's the heavy. Gotcha. Euphemism. I gotcha. I am a Sopranos fan, and I'm not familiar with Wetworks. Gotcha. Makes sense. I got you now. I know the term fixer. She's the fixer. She's the heavy, but I never heard Wetworks. Gotcha. I learned something new today. Morag, how are you? Has he been locked up? No, he got out. He went in 85. He got out in 97. Went back in 2003, and has been in since 2003. It's another term for a fixer. Gotcha. So it seems like YouTube's issue may have cleared up. Debbie did report to YouTube. She said a couple times she messaged YouTube. I learned something new today as well. So Richard says, I also use Bluetooth for your hearing aid. Daily I have to toggle off and then on to reconnect it. It seems like the YouTube issue may be fixed. Almost 10 minutes and counting so I think it might be fixed. Way to go, Debbie and Richard, for getting on YouTube. You guys won the internet. You guys won the internet for us. Morag, thanks. I've not been able to watch it at all. Yep. Yeah, he shot a couple people in 85. A couple different instances. I think when he waved a firearm in somebody else's face. 2 people died from that. He did involuntary manslaughter, got 12 years for that, got out in 97. Then he was arguing with his girlfriend in 2002 in Oakland. Her friend came over or was there, tried to break it up, went to call the cops. He comes out and he shoots her twice. Then he runs to Florida and then does this to Theresa. And then they find him in Houston. And then he gets taken back to California, and then they find enough information on him here in Florida, and they extradited back here. I think it was 2015. Excuse me, he came back in 2015. So that pretty much brings you up to speed. 30 minutes and you're fine. Very cool. Kathy, you don't have Apple product. I don't think it matters because it wasn't specific to Apple or Android or Google or anything like that. It was not specific. Kimbers, we have a rule at work that before we go to the IT person, turn it off, turn it back on. That is why they ask anyways. Yep. Is it plugged in? Is it turned on? Turn it on again, turn it off. Yeah. That's pretty much it. That's pretty much it. Yeah, one became a paraplegic. The other one passed away. That is always the first thing IT says to do. I agree. Richard, why don't you get a burn in your rear like a dog with a bone? JMS, is it really that hot? Well, you're welcome, Morag. No problem. Yeah, I literally just summed it up in like less than a minute. So there, consider yourself up to date. Oh, and the jury found him guilty here in 7 hours. It took them 7 hours, but they listened to like 2 hours of playback or replayed testimony. They had the poor court reporter read back the testimony of one of the medical examiners. It was a battle of the experts, so The state brought in a medical examiner, so did the defense. Neither one of them did the autopsy because it was done by somebody else and they're no longer around. Who knows what happened with them? And the jury first of all asked, can we see the transcript? And the judge says, nope, doesn't exist, or we're not going to give it to you. Rely on your memory. So they're like, okay, we want to hear it back. So they trotted them all out, and the poor court reporter had to read back the medical examiners on the state side, and that took like 2 hours or something, hour and a half. So, Ronnie V, no break. I'm sorry, no word yet. You took a break, no word. Still, hour and 31 minutes and counting. Michelle, we will be covering Charles Jones, a.k.a. Julio Fulio, out of Jacksonville. He went to Tampa Bay for his birthday, and he was shot and taken out by a rival gang. So we're going to start our deep dive tomorrow. So that's tomorrow. We start our deep dive with covering the beef, the history of the beef between the two gangs. And then we're going to do NASA. We're going to cover NASA again. We'll do press conferences. That's tomorrow afternoon. And then Thursday, we're going to look at Julio's life. And then from there on out, we're going to do pretrial hearings with Davion Murphy. Well, focusing on Davion Murphy. That's the one that we're following. But there's 4 defendants. But our focus is on Davion. Paul Canero is May 12th. May 12th. Here's the, those are the 3 coming up. So Brendan Banfield's the 8th, Paul Canero's the 12th, Corey Richens is the 13th. So those are the 3. And then Carlos Dominguez is after Charles Jones. So we got Charles Jones and then Carlos Dominguez. Carlos starts in May as well, May 7th. So depending on... Charles Jones has been in jury selection since the 7th, I think. No, the 8th. The 8th. They've been in jury selection for almost a week. Yeah. The judge thought it would take them about 2 weeks to come up with a jury because there's like at least two lawyers per defendant, and there's 4 defendants, so it's like 8. I think, I'm not sure if it's Isaiah. I think it's Isaiah Chance that has like 4 or 5 lawyers. I'm not 100% sure. Or Sean. One of them, not the Murphy. The Murphys are cousins. It's either Sean or Isaiah have like 4 or 5 attorneys. And that's a DP case too. All of a sudden, we're doing all these DP cases. It's not by choice. It's just they just happen to be going on right now. But yeah, that the Charles Jones one is a DP case. Alicia Andrews went to trial back in October. She was found guilty. Halloween night, she was found guilty as being a lookout. And now the other 4 are up for the DP starting maybe next week. I hope next week. I'm not sure. The focus command will be worn out for this trial. Corey's trying to change her date. Oh, paper. Okay, thanks. We will not, Ronnie, because we're after this trial, this current trial is over, we're going to shift our focus over to Charles Jones. So, yeah, no. You're welcome. Selena K is on the plane to Hawaii. Awesome. Oh, have safe travels. And I was going to say have a wonderful time, but as I said yesterday, I know you're going to have a wonderful time. So, Selena, how long are you going to be there for? How long? Like 2 weeks, a month? How long do you go? How long does one travel to paradise? How long are you going to be there for? That's one state I've never been to. I've never been to Hawaii or Alaska and the Northwest. I think I've been to every other state except Oregon, Washington, Alaska, Hawaii, and I think Maine. Yeah, those are the what's that? 5 states I haven't been to. How long will you be there for? Yes, please send pictures. Selena said she was going to send pictures. I'll show them to you guys. Iowa backyard, yes. Paradise for us was New Zealand. Oh, I'm so jealous. I would love to move to New Zealand, to be quite honest. After watching Lord of the Rings, I'm like, yes, sign me up. I want to live there. Absolutely. 7 days. Oh, that's wonderful. That's wonderful. Too bad you couldn't like multiply that by 7. 7 times 7. That's awesome. 7 days. Gotcha. Thank you. Thank you. Selena will send pictures. Awesome. Awesome. Can't wait to see those. I will definitely show. Selena, do you want me to wait for you to get back to show those, or how, do you want me to show those before? Like, how do you want me to do it? Well, we can talk. I'll text you. Like, do you want me to show? Basically, do you want me to show pictures? You know, while you're still there, or wait till you get back. Christine, I should come to Scotland. I would love to go to Scotland, but if you do, bring wellies and an umbrella. I was to England. I went to England. I went on a castle tour, but I did spend 2 weeks in England. That was fun. I love the British Isles, the UK. So, I have not been to Ireland or Scotland, but I have been to southern England, I guess. Basically London, east and west, and a little bit north. Leeds, I went to Leeds Castle. I forget all the castles I've been to. Went to about 7 or 8, I think. Went to about 7 or 8. Selena, you may not come back. Okay, wait until you're back. Okay. Wait until you're back. Okay, sounds good. Yeah, right. Any more Hawaiian trials? Oh, well, we can't take on any more trials because we're going to do Charles Jones and then Carlos Dominguez. So we're booked up with trials. Carlos is going to be a solid month. Charles Jones is probably going to be 3 weeks to a month. 4 defendants, right? So we're booked up for like the next 2 months. And after in May, let's see, June, and then July, we have, it looks like, let's see, May. Yeah, probably June and July we need. And then we have Shanna Gardner is in August. And Courtney Clenny's in August too. Ugh, we're going to have to make a decision there because I'm going to go to Shanna Gardner. I'm planning on going to a couple of days of Shanna's. But I think Courtney's has been changed too. Missy Russell, come to the Pacific Northwest in the summer where you can actually see how beautiful it really is. I love the Pacific Northwest. I love mountains. I love green. I love trees. I love everything about. I love rain and mist. When I saw Rambo, I know this is really weird, but I saw Rambo in the movie theaters, and I was like, "Oh, that's a cool place. I would love to be there. I would love to be there." New Zealand is beautiful, Elaine says. Holiday there for a month to visit old school friends who emigrated there. South Island, I could well up sticks and move there. Yeah, I would move to New Zealand. Scotland is beautiful but cold. I know, I stay here. Yeah, well, I'm okay with that. Nick says the York Viking Museum is great. Scott's watching the Utah trial. All right, maybe we can shuttle over there afterwards. There aren't enough hours in the day for us trial watchers. That is true. That is true. That is true. Let's see here. Hey, Play on Crime. There you are. Welcome in. I don't think so. JMS, I haven't heard. I haven't heard of that. I have not heard that. I don't think so. I don't think so. The UK is always cold. Today it's wet and windy. Well, I was there July, like basically July 4th, like a week before, a week after. And I took a raincoat, which I used. Never wore shorts. Didn't even bother taking shorts. I don't have to tell you guys that live there. But it was pleasant. It was definitely pleasant. It was like in the 60s, I think. Maybe hit 70 once. It was pleasant, but I was expecting that. Oh, yes, Ireland is definitely beautiful, for sure. Ireland is beautiful. I love mountains. I love green. Anything that's green and mountainous, count me in. Eastern Europe, Switzerland, Croatia, yeah. Italy. I mean, there's so many beautiful places. Right, Super Bowl? So many beautiful, right? Yeah, so many beautiful places. They dropped it. It was there? Okay, I didn't know that. Good vibes. I don't, during our pretrial hearings, I don't remember ever hearing about it. UK is great, but Ireland is fantastic, and the Ulster Museum is a must-go-to in Belfast. Very cool. We have our really good friend Maureen, who was in our chat for the splashdown. She's Irish, so she has been there. She just went there, I think, a year or two ago, and then my brother and his wife were just in Ireland. We're just in Ireland. Stop it! Stop. That is totally uncalled for. They just got back. About 6 months ago, or not even, maybe a couple months ago. Yeah, just go over there. Stop. Just stop it. Just stop. Stop. Yeah. You're being mean. Okay. Just stop. Yes, Mo knows exactly. Debbie, you went there for your niece's wedding? Nice. Yeah, Japan. I fell in love with Japan when Shogun. Remember Shogun back in the 80s? I watched that. I think it was the 80s. When I watched Shogun, I was like, oh, that's beautiful. She is being fresh. She's smacking poor Roger. Roger's just sitting here. He's sitting right here, being all cute, and she just goes up to him and starts smacking him. Just stop. Kids. Debbie, yes. Yeah, it seems like it's cleared up. Whatever the issue was, it is cleared up. So, you and Richard won the internet by contacting YouTube. Whatever you guys did, it worked. YouTube is fixed, yeah. Yep, seems like YouTube is fixed.
And Mo was in Ireland. Mo was in Ireland about 3 weeks after your brother was there.
Oh, 3 weeks after.
Like 2 months ago.
Okay. So Mo was there 3 weeks after my brother was there. So, yeah, here, look. This is what she does. So she'll go there and then she'll just sit there and smack him. And he's like doing nothing wrong. Come here, buddy. Yeah, good boy. And she'll just sit there and she'll just smack him. For no reason whatsoever. I know, right? She's Professor Grumblepants. Let the kitties out. Yeah. Professor Grumblepants. Super Bowl is not being very nice right now. She has her moments. That's a naughty tale. I always know there's trouble brewing when your cats do that. Yep. Right, they're thinking, right? Isn't that what their cats are ready to do something bad? Yeah, now that closings are done. Do your kitties like cardboard boxes? Yes, everybody does. Yep, everybody likes cardboard box. Yes. And JMS, yeah, YouTube seems to be fine right now. YouTube seems to be fine right now. Brett says, we loved Ireland. It's in the short list. We'd spend another vacation to go back to, along with New Zealand. Yeah, boy, New Zealand. I'd love to get to New Zealand. Super Ball was the first cat. Correct. She's asserting her dominance. She did really well as a only cat. She even did that to her brothers. Her own brothers, they would try to come into the house and she would chase them out. So she was she's very dominant for sure. She does really good as an only cat. When she has to share time, then she's not so good with sharing time. Okay, buddy. She's not too good with sharing time. She prefers to be an only cat. Yes, she is scheming. She is scheming. Did I have a chance to look at the tab? Not yet. Yes, the box the present came in is always the favorite present. That is true. Basu, you loved visiting Wales. Sparkling Princess, got to remind them who's boss. That is true. Oh, Richard, yes. I'm sorry. I looked at it. I did not have a chance to sit down and play yet. I haven't had a chance to do that yet. Getting ready for the Charles Jones trial has consumed me. Putting together the 2 videos that we've put together so far has just taken over my life for the last 3 days. And that's just putting it together. Then there's all the research that came before that. So, Richard, I will get to that. Probably I don't know if I'll get to it this week. Certainly over the weekend. Yeah, just kind of been consumed in Charles Jones prep just to get you guys content that is accurate and worth streaming. So I literally have been consumed by that, as has Erin. Erin's been working on it for a long time too, as she is continuing to work on it right now, even as we speak. I'll check it out, Richard. I'll check it out. Linda, your Kitty is living in his Cartier. I don't know where he wants to go. I leave it out. Easier to get him in when it's vet time. Christine, my daughter only has 1. She's a really pampered kitty. My son has 2, a boy and a girl, not related, and she's definitely the boss between the 2. Aussie, yes, I shall tag you. Let me see here. Okay, let's try that. Debbie, you want to go to Alaska to see the orcas and glaciers? My mom did a cruise of Alaska. Yeah, she said it was pretty cool. Julio is in Florida. Yep. Tampa. It's going to be Tampa Bay. Hillsborough County. There we go. Yeah, back to back, right? JMS, back to back Florida trials, back to back DP trials. And then we're going to totally switch gears and go out to California. We're going to go out west with Carlos right after that. And Raul Valley, if anything ever comes of that trial, we're definitely going to cover that trial again. We'll see if see if anything comes of him. He's still kind of in limbo. So we have Charles Jones, we have Carlos Dominguez, we've got Shanna Gardner, Courtney Clenny. Although Shanna, Mario, and Courtney are all going to be in, well, that got severed. So Mario is first, and then Shanna, and then Courtney's thrown in there somewhere. She's in August as well. I hope she gets kicked down the road because I really, really, really want to cover her, and I don't want to not cover her because we're covering Shanna. So those will be long days because we'll be streaming both. I'm not going to give up on Courtney. Definitely going to watch Courtney. But Shanna, if I'm going there, I got to figure out how I'm going to figure out Courtney. So those are the big ones. Yeah, those are the three. 1, 2, 3. Yeah, those are the three big ones. And Mario, of course, would be the fourth one. But those are the. Oh, hey, they're back. They're back. Okay, that was weird. There was microphone came on for a hot second. Okay, so we got Charles, Carlos, Shanna, Mario. I'm going to count those as the same. So that's 3, and then Courtney. So that's four big trials coming up. I'm not sure if we'll dual stream per se, but we'll do a stream after. We used to do dual streams, and we're kind of going away from them because I think it splits our mods, it splits my attention, and it splits our chat. So I'm kind of shying away from the dual stream, unless you're in Verdict Watch like we are now, and then we could be streaming another trial. I'm okay with that. But even then, it splits. Yeah, if Shannon and Courtney are on at the same time, I know that's really, yeah. I will not be happy. I agree. Ian Mitchum is finally over. Yeah. Gordon, that trial promised to be really, really interesting, and it was, but then the streaming was just, sometimes they'd stream it, sometimes they wouldn't. They give us a day, they give us a half a day. It was just hate it. Thank you for that, Margaret. Appreciate that. Debbie says going on 2 hours. Yep, you said 2 to 3 hours. I said 2 to 3 as well. So, JMS, you still think, you still think Raul isn't going to trial. All right. You think a plea? You think he'll take a plea? Aussie, I have gone out on a boat and watched the whales. They came right up to us. Very cool. Wow, they are huge when they are up close. I did a whale watching off of, it was Cape Cod. It was off of Providencetown, P-Town. I guess it was Providencetown. And, yeah, we did whale watching, but it was a biggish boat. It was cool though. We definitely saw whales. That was fun. I don't know. I do want to cover that. Let me see if I can find anything. The only thing when I say cover, I wanted to at least do the verdict. All right, I see a verdict. 4 days ago, verdict came in 4 days ago. So his verdict came in 4 days ago. Yeah, they stopped streaming. They stopped streaming it, and then it's just the they stopped streaming it, and it's just news. So his verdict came in 4 days ago. Morig's looking forward to Courtney. It's in August. It got changed. When is it? August? Is it August 10th? Or when is Courtney? They might be coming back, you guys. They might be coming back. Let's see. Courtney Clenny, trial date. All right, was scheduled for April 27th, which we knew. Wow, that's an extreme close-up. All right, so from Court TV. Wow, dude, seriously. Now we get to see his earwax. Seriously, dude? All right, while no specific date was set, the party said they are hoping to schedule the trial to begin in August. So I guess nothing has been set. This is from April 1st from Court TV. So no firm date according to Court TV on April 1st. So sometime in August. They're hoping sometime in August. That's a whole lot of ear. Aussie. Just use the emoji then. You can just use the emoji. Germany, who? That cameraman needs to be fired. Right? I'm not going to stop the clock until we have confirmation that it's a verdict. Yeah, if I don't type for a while, that does happen, right? We've had that problem before. There is a verdict. Let me see if Kathy Russin is saying anything. Jury has a decision. Stand by. Okay. Kathy Russin says jury has a decision, so I'm going to pause it. So a verdict is in. Kathy Russin is saying jury has a decision. Stand by. Jury has a decision. Stand by. That's Kathy Russin. All right. Jury has a decision. Not a question, but they have a decision. All right, so we have a verdict. Apparently we have a verdict. According to Miss Russin. All right, so I'm stopping it at 1:58. That's according to Kathy Russin. So we have a verdict. 1:46. So 1 hour, 58 minutes. We think so, Heidi. Kathy Russin is saying the verdict, jury has a decision. Stand by. All right. According to Miss Russin, and we tend to trust and believe her, but let's see what happens. How many courtrooms can Kathy Russin sit in at one time or at the same time? Yeah, I would think so too, I would think so too. 2 hours wins it. All right, and we wait. Remember, she said 10 minutes. She said 10 minutes. For the guilt phase, she said be within 10 minutes. So we'll see. Barry says, folks, remember most of us will not agree at the same time with the verdict recommendations. Let's respect their verdict and findings and appreciate the process. Green-eyed cat, I guess I'll wait a few. Then if we have a verdict, yeah, we should be. Judge said be within 10. Well, this was for the guilt phase. She didn't say anything we didn't hear for the penalty phase, but the guilt phase, she said be within 10 minutes after the jury rings the bell. Be within 10 minutes. 10 minutes away. 10 minutes call. Well, they called it about 6 minutes ago. So I would say within 5 minutes, probably at the top of the hour, maybe. I don't know if they're going to wait until 2 or if it'll be read before then. For the guilt phase, Ed, she said be within 10 minutes, and it's been about 5 so far. So I would say any minute, to be quite honest, any minute, but no more than 5 minutes, I would say. All right, I would say even right now. All right,
Let's
right
bring
now.
him in. Record to reflect that counsel for each party is present, as is the defendant, as he has been.
Jury's in order.
You may be seated. Ladies and gentlemen, I understand that you've reached a penalty phase verdict. If you could fold the verdict form over and hand it to the court deputy, please. The verdict is in proper form, and it reads as follows. In the Circuit Court of the Ninth Judicial Circuit, and for Ninth Judicial Circuit of the State of Florida and in for Orange County, State of Florida versus Demorris Ann Hunter, case number 2002 CF 6796. We, the jury, find as follows as to Demorris Andy Hunter in this case. We, the jury, unanimously find the state proved beyond a reasonable doubt that Demorris Andy Hunter has previously been convicted of another capital felony or a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has proved beyond a reasonable doubt the existence of the fact that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, have unanimously found the state of Florida has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient to warrant the death penalty and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris Andy Hunter should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 12-0 that Demorris Andy Hunter should be sentenced to death. Dated this 14th day of April 2026 in Orange County, Florida, signed by the foreperson. Ladies and gentlemen, I'm going to ask each of you about the verdict that you have just heard. I'm going to ask that you look at your badge number because I will ask this question by badge number. Do you, badge number 645, agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, I do, Judge.
Thank you. Juror 331. Do you agree that the recommendation as read by me accurately reflects the recommended penalty? Yes, Your Honor. Juror 739, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 244, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 341, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 277, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 307, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 414, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 217, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 2203, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 40, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 243, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Thank you. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And I want to personally extend my thanks to each of you for being here. I know when you showed up for jury duty 2 weeks ago that you did not anticipate that you would be asked to make such a weighty decision. I appreciate your willingness to sit through this process and to come to a conclusion. We will have, before I excuse you, let me see the attorneys up here for just a moment. Ladies and gentlemen, the court deputy will have some work excuses for you. And after you receive your work excuses, you will be free to go. If you receive another summons in the next year and you do not wish to serve, just check the box that you've served in the last year, mail it back in, and you're automatically excused. And I do, again, want to extend my thanks for you being here. I'm sure that you recognize that we do some very weighty things in this building. We could not do those if we did not have citizens that were willing to participate in the system. I hope you saw that when you came and left the courtroom, we stood. We did that in very small recognition of the very important service that you're paying to each of us by being here. So thank you, and have a good day. He did not get the work excuses. All right. We need to schedule the Spencer hearing. How long do you need to prepare for the Spencer hearing?
Could we pick a date in June, Judge?
Okay. How long do you anticipate it will last?
A day.
A day? Okay. Could do Monday, June 1st.
That works for me. You can see, Rachel.
Yes, Your Honor. We have a Huff hearing on Miller, but I think the AG can handle that.
Yes, ma'am. That'll work.
That work for you, Mr. South?
Yes, Your Honor.
All right. Then we will set the Spencer hearing for June 1st at 9 a.m.
Thank you.
And after, I will also want sentencing memoranda from you 30 days after the Spencer hearing.
Okay. Very good, Your Honor. Yes, ma'am.
And then I'll set the actual sentencing for about 30 days after that.
Okay.
All right?
Yes, ma'am.
All right. Very well. Then we will be in recess.
Thank you, Judge. Thank you, Your Honor.
All right. So there you go. Spencer hearing June 1st, and we saw this with Jose Soto Escalara as well. They did a Spencer hearing. They did theirs a lot faster, though. Let me go back and look at that. I think they're going to, looks like they're going to end it here. Just wait till the judge gets off the bench there. All right, now she's gone. All right, so Jose Soto. Jose Soto Escalara. All right, so Jose Soto was found guilty September 23rd Then they did the penalty phase, which was September 25th. And then they had a Spencer hearing October 6th. So that was only like maybe 3 weeks. Yeah, that was only like 3 weeks, whereas this one is going to be June 1st. So that's like 6 weeks. And then the decision was October 10th. So his decision was only 4 days later. Then she says she's going to need 30 days after that. So that's going to be July. So this is taking much, much longer than Jose Soto. So Heidi, I think I saw you said this is the first DP case you've seen where they come back unanimous, or they come back and they recommend it. This is now our second. We did Jose Soto Escalara, and now we've done Demorris Hunter. And then we're going to do Charles Jones next. Charles Jones will be next. All right, so quick recap. The jury came back after just under 2 hours, hour and 58 minutes. They came back with a 12-0. 12-0. 12 in favor, 0 nays, if you will. They felt that the state proved Demorris Hunter had previously convicted felonies. I think that one was pretty easy. And then the heinous, atrocious, and cruel, they came back and said the state proved that as well. That one I may have been a little bit more on the fence with. That. Jose Soto Escalara. All right, he's the one that he was married and he was messing around with a female that was younger than him, and she got pregnant, and he was the garbage truck driver, and he threw her away on the side of the road. Do you remember that now? Jose Soto Escalara. Tanya Wise and their unborn child. You remember that? And that's where the defense attorney called the judge an idiot. You remember all of that? So this was also in Orlando. This was south of Orlando. Oh, it's St. Lucie County, so it's a little bit south of Orlando. Lawrence Merman was the judge. Remember him? A lot of you weren't really keen on him. August 2018, the body of Tanya Wise was found face down in a ditch off the rural road in northern St. Lucie. He was 41. She was 23. He was arrested 28 days later. She had suffered trauma to her head and throat. Do you remember that now? And I think she was 8 months pregnant. 8.5 months pregnant, something like that. So. Yeah, she was 23, he was 41, and I believe she was 8 months, if not 8.5 months pregnant, something like that. So, yeah, the tape recording, remember all of that? He was driving around with his buddy, fellow sanitation worker. Yep. Heidi, you saw half of that one, yeah. So, this is third. Your third DP. No, they weren't. No, he was married, but no, that was not her uncle. Yeah, he was married. Shirley, do you remember if he had kids? I can't remember right now if he had kids or not. I forget. Alabama carried out 5 DPs in 2025. He eliminated the pregnant girlfriend, talked about it in garbage truck with his cousin in Spanish, right? Yep, that's pretty much it. Richard, you're going to sleep? You're saying goodnight? All right, Richard. Okay, there. Good night to all. Okay. Okay. Debbie, did they consider the baby a victim too? Yeah. Yep. Yeah, that's And they came back 8-12. They came back 8-12 on that, you guys. That wasn't even unanimous. You would think, if anything, that would have been unanimous. It was not. They came back. Hold on a sec. Yeah, they came back 8-4. 8 were for it, 4 were against it. So they were not unanimous. Can you imagine that? Here, this guy takes out his mistress and their 8-month-old unborn child of 8-month unborn child, and they went 8-4. Whereas here they go 12-0. It was his cousin, yeah. Okay, thank you. So, yeah, the big issue was that, the interpreters, remember they had a court interpreter, they had another interpreter, and it was kind of what the defense was going back. The defense was kind of going back and forth about, well, it's your interpretation literally versus my interpretation. Yeah, all that stuff. Yep. Iowa backyard. On a happy note, your eldest daughter and boyfriend have purchased a first-time home. Partially shares yards with where they've been living with her dad. Nice. All right, Gina, have a good one. Thank you for joining us. And you guys, let's do a raid on Scott. Is Scott still around? Let's go raid RA. Scott still going? Yes. All right. He's in day 1. If you guys want to go watch Tracy Grist, let's go do a raid on RA. Oh, it's fun. Let's go do a raid on RA. All right. Let's go raid RA. And let's see. Where is redirect? Why can't I find redirect? Oh, there it is. All right. Okay. All right. Yes, let's teleport over. Let's go check out RA. He's day 1 of a new trial that just started. So I will say goodbye here. Tomorrow morning, we're full on Charles Jones. So Demorris Hunter is over with. He got the DP. He was found guilty, and a jury of 12-0 sentenced him to death. And Spencer hearing will be coming up June 1st, which we will cover, and then sentencing will be a month after that. So appreciate you guys watching this trial with us, and thank you to our mods. Thank you to Aaron. And now we will turn our focus to Charles Jones. So we will be we'll be doing some deep dives over the next 3 days with Charles Jones. So thank you guys for joining us. I have set a redirect over for RA. He is covering a new trial if you want to go check that out. But I do hope to see you tomorrow as we pick up coverage of Charles Jones. So with that, have a fantastic rest of your day, and I'll go spend some time over with you guys at RA. So take care, and we'll see you over at RA, and if not, then we'll see you tomorrow, 9 o'clock Eastern, for deep dive into Charles Jones. Have a good night, guys. Bye.